I have filed a opinion opposition, that may be called from.
With consent of the other party, I beg to mention 47.
Use your mic, madam. Use your mic, yes.
With consent of the other party, I beg to mention. Mike, 47.
Item
47. My senior counsel, he has unwell. Matter may come up after 1 week, Lordship.
My lord, here I have got the para wise, my lord. I will file the affidavit within a week. Regarding an industrial policy, my lord. Industrial policy, my lord. From 2019, he is not entitled otherwise.
Mr. B. Gogoi, the learned additional advocate general, appearing on behalf of the Industries Department, submits that within a week's time, the affidavit in opposition would be filed on behalf of the said department. Considering the above, list this matter on 28th of August 2026. Petitioner granted liberty to file reply thereagainst.
Oh, bless you.
May it please your lordship. Lordship, in item number 24, we have filed an additional affidavit that may be called for. Much appreciated.
He will appear, my lord. I have sent the link. Otherwise, my lord, the FOC has been sanctioned yesterday. By today, probably it will be, the principal amount will be, my lord, deposited. After some time, my lord, let it make the statement.
On the last day also, my lord, the contemptor had said that he will pay the amount before the next date anyway. My lord, till that amount has not been released.
Yesterday, my lord, we got the FOC. So it will be now deposited to the account of the petitioner. FOC, my lord, approval we have got, my lord. That is the final stage from the finance department. So by today, probably it will be deposited. He will be online, my lord. I have sent the link just now.
How much is the amount?
One is 27, another is 34.
My lord, in item number 17, the amount is 27,25,344 rupees, my lord.
When is he likely to get the money?
Well, let him appear, my lord. He will make the statement because he's aware of all these facts. I have sent the link. He will appear on VC. After some time, my lord.
There are two matters.
7 and 8, my lord.
Okay. 7 and 8.
7 and 8. 7 and 8.
This is 41 lakhs.
My lord.
Why the FOC is for 57 lakhs?
Item number 8, in item number 8, my lord, the amount is 41,74,300, my lord.
Well, let him reply, my lord. Why? It may have some reason. $165.
165. 41 lakhs and 27.
Who is the contender?
He is a chief engineer, my lord. Rotikant of Pegu. Chief engineer, PWD, Boda Roads and NEC Works, my lord.
You do one thing.
He is online, man.
Yes, Mr. Chief Engineer, why the amount have not been released?
Sir, we release it. Today this will be credited in their bank account, sir.
Huh?
This has been released from such financial sanction has been given, and today it is expected to credited their account, sir.
Now, I fail to understand one thing. One problem, there is no problem about one case wherein the amount is some 27 lakhs. But in other case, it is said to be 41 lakhs. Why the financial sanction is only for 37 lakhs?
Sir, this was the actual amount, sir. The contractor also confirmed it, and he given his undertaking that the amount is not 41, this is 37, sir.
Okay.
We agree, sir.
So
This
we
will
do
be credited today, sir. It is in process, sir.
okay, we do one thing. We have it on. As you say that it will be credited today. We have it
Yes.
on next Monday for an update.
My lord.
Okay.
Okay, okay, sir.
And if it is credited, you need not appear.
Okay, sir.
Mr. So and so, the
My lord,
chief
there is
engineer.
also regarding the interest part, my lord. Lordship, if you kindly present at page number 23, my lord. It was also said that sale amount shall carry interest at the rate of 6% from the date the petitioner, as per the contractual terms and conditions, was entitled to refund the security deposit, my lord. The amount has been released after a lapse of around 11 years, my lord, in item number 8, my lord. It was payable on 29/10/2016. And your lordship, in the order passed in the petition clearly directed.
No, first of all, Lordship, in the contempt case, on the last occasion, Lordship directed that first the principal amount should be paid. There is order dated 22/6/2026 in the contempt case.
20.
Then 22/6/2026. Para 6, Lordship will see. Then no, the interest part will be looked into. That was the, my lord, Para 6. In both the case.
Mr. So and so, the chief engineer PWD, border roads and NEC works is present.
Yes, sir. Yes, my lord, the contractor has given undertaking that he do not claim the interest for, sir.
Huh?
He agreed that he is not interested in demanding that interest for.
I am not aware, my lord. I will take instruction, my lord.
It's okay. Let that be. Has he given you a written, anything in written?
Yes, he has given undertaking.
I will place it on the.
He is satisfied with.
Let me pass the order, Mr. Pegu.
Yes,
Mr. Ratira Kanta Pegu, the chief engineer PWD border roads and NEC works is present before this court. They in as much on the day as the amount of the security deposit of rupees 27,25,344 is yet to be released. The chief engineer,
Yes.
Mr. Pegu had submitted that
Yes.
the financial sanction has already been granted for the release of the said amount, and the same would be credited to the petitioner's account during the course of the day. On the question of interest, it was submitted that the petitioner had given an undertaking that he would not claim the said interest. Considering the above, list this matter again on 12th of August 2026 for an update. On the next date, the presence of the chief engineer PWD is not required. Mr. B. Gogoi, the learned counsel who represents the contemner, shall produce the undertaking which have been submitted before the PWD department by the petitioner as regards not claiming the interest. এইটোত হ'ল, হা? ইটো কেছত লিখিব এটা কথা, that is 41 lakhs বুলি ক'লে নহয়? This court put a specific query upon the chief engineer, PWD, as to why the amount which is sanctioned is rupees 37 lakhs 25,280 and not rupees 41 lakhs 74,300
300.
as mentioned in the order dated 22/6/2026. The chief engineer, PWD, admitted that pursuant to the order dated 22/6/2026, on reconciliation of the accounts, is the perusal of the materials, reconciliation of the accounts with the petitioner. It was found that the security deposit submitted by the petitioner was 37 lakhs 25,280. And it is under such circumstances, the financial sanction has been granted only for the amount of rupees 37,25,280. বাকিখিনি আগৰটো নিষ্ঠাকে ভৰাই দিওঁ। টেষ্ট কথাত দিয়া।
On 10th, my lord, Monday, 12th.
Obliged, my lord.
এই দুইটাতে ডকুমেন্ট মার্কড এজ এক্স, হ্যাঁ? ফাইন্যান্সিয়াল স্যাংশনস का एक्स हो जाए।
Obliged, my lord.
The appearance of the personal appearance, the appearance of the chief engineer PWD is dispensed with.
May it please your lordship. Lordship, I have the instruction to withdraw this petition, lordship.
Mr. M.K. Bora, the learned counsel appearing on behalf of the petitioner, submits that he has instructions to withdraw the instant writ petition. Mr. S.K. Talukdar appears on behalf of the Corporation Department of the Government of Assam. Taking into account the above, the writ petition therefore stands closed on withdrawal. Interim orders, if any, stands vacated.
Obliged.
May I please your lordship? Lordship, the service upon all the respondents have been completed.
The service upon all the respondents being completed, comma, as would be apparent from the order of the Lozima Court dated 27/7/2026. Nothing further remain, this court directs the instant writ petition to be listed for admission.
Lordship, the interim may be continued.
Wait,
Lordship.
when do you want the admission? On 7th of September 2026. Interim order which was passed on 9/1/2023, hence extended till the next date.
Sure, please, Lordship.
May it please your lordship. On last occasion, lordship wanted to place the instruction whether 5 lakhs compensation would be paid to the victim, my lord. My lord, there's some paucity of fund. So right
It's a
now.
different thing.
My lord,
Yes.
Question is, should it be 3 lakhs or 5 lakhs?
5 lakhs. My lord, as
2
per
lakhs,
this
2
notification,
lakhs or
2
5?
lakhs was granted,
Because you see, he is otherwise entitled as per the scheme,
my lord.
merely because of the judgment, which did not take into consideration the notification dated 1/2/2019.
Correct.
The amount of compensation cannot be reduced.
Cannot.
So this is under what? 357.
357, my lord. My lord, the trial court has no jurisdiction to fix the amount, my lord. The trial court, my lord, has no jurisdiction to fix the amount, my lord. The trial court jurisdiction only to recommend, my lord. My lord, three
No,
fifty-seven.
that's a different
Difficulty is,
thing.
my lord, this
Yes.
order.
No, there, unless there is any reasons assigned. Where is that here, victim?
But victim,
Reasons so assigned as to why the petitioner should not get lesser amount than what is there in notified. The judgment passed by the learned trial court cannot override your claim of rupees 5 lakhs.
Yes.
To be disposed of. Heard Mr. M. Hussain, the learned counsel appearing on behalf of the petitioner. Home and Political,
Lordship.
Mr. S.S. Roy appears on behalf of the respondent number 1. Mr. No Finance. Ms. P. Chakraborty appears on behalf of the respondent number 3, 4, and 5. The finance department, however, is not represented in spite of their names being shown in the cause list. The petitioner herein is aggrieved. They have got 2 lakhs
Yes, my lord.
by the reduction in the ex gratia amount. Paid to the petitioner on the basis of the order dated, judgment dated 8/4/2022, passed in special POSCO case number 30/2018. It is the specific case of the petitioner that in exercise of the powers conferred by section 3757A of the Code of Criminal Procedure 1973, the governor of Assam had framed the scheme for providing funds for the purpose of compensation to the victims or his or her dependents who have suffered loss or injury as a result of the crime and who requires rehabilitation. The said scheme was called the Assam Victims Compensation Scheme 2012. In terms with the said scheme, in terms with the schedule to the said scheme, the compensation which is payable on account of what has happened here? On account of rape was 75,000. Subsequent thereto, by the notification dated 1/2/2019, compensation which was payable earlier was enhanced. The ex gratia which was payable was ex gratia compensation which was to be payable earlier in respect to various injuries oblique loss have been enhanced. And in the case of rape victim, the minimum compensation is rupees 3 lakhs and the maximum is rupees 5 lakhs. Next. It is the further case of the petitioner. That who is the petitioner to the victim?
Father of the victim.
His daughter was raped on 2/5/2018 on the basis of a FIR so filed. A case was registered as Colgosia PS case number 347/18 under section 4 of the POSCO Act. The charge sheet was submitted before the learned court of the Session Judge Borpeta, and a case being special POSCO case number 30/18 was registered. The said wider judgment dated 8/4/2022. The learned court of the additional sessions judge cum special judge POSCO at Borpeta convicted the accused so the learned trial court was of the opinion that the petitioner that the victim ought to be compensated accordingly. Directed payment of ₹2 lakhs as compensation to the victim for her rehabilitation. You filed an application.
Yes, my lord.
Well,
File application, my lord. Yes, my lord.
subsequent thereto, as petitioner was paid an amount of ₹2 lakhs
On 3/3/2025.
on
3/3/2025.
3/3/2025. 20?
Five.
No. Prior to that,
9/8/23.
huh?
Payment was made, my lord.
The petitioner. No, yeah. Also. It is very relevant to take note of that on 9/8/2023, the petitioner, who is Hazrat Ali, you filed.
Yes.
The petitioner filed an application before the member secretary of the Assam State Legal Service Authority for granting compensation of ₹5 lakhs. In the said application, it was mentioned that though the learned trial court had granted ₹2 lakhs as compensation, but in terms with the notification dated 1/2/2019, the compensation payable between 3 lakhs to 5 lakhs. The said application being not considered, the petitioner approached this court by filing the present writ petition. Next. It has been submitted before this court by the learned counsels appearing on behalf of the parties. That in the meantime, when did you get the 2 lakhs?
3/3/2025.
On 3/3/2025, the petitioner have been paid an amount of rupees 2 lakhs. This court, by an order dated 22/6/2026, sought for instructions from the respondents as to whether it is permissible to direct payment, whether it is permissible to reduce the compensation payable to the petitioner by an order passed by the court when there exists a notification as on the date of the judgment thereby quantifying that the compensation, ex gratia compensation to be payable is between rupees 3 lakhs to 5 lakhs. This court heard Mr. M. Hussain, the learned counsel, appearing on behalf of the petitioner, and Mr. S.S. Roy, the learned government advocate, and Ms. P. Chakraborty, the learned advocate, appearing on behalf of the Legal Service Authority. This court have also perused the judgment passed by the learned trial court, wherein paragraph number 23, the learned trial court was of a categorical opinion that the petitioner, that the victim was entitled to compensation. Be it as it may, the judgment of the learned trial court do not mention as to on what basis the amount of 2 lakhs have been quantified. That too when, at the time of passing of the judgment, the notification dated 1/11/2019 was holding the field. In the above, in view of the above, it is therefore the opinion of this court that when there is when there exists a statutory notification define the compensation under the Assam Victims. What is the name? Assam Victim Compensation Scheme 2012. Reduction of the compensation and there being no embargo, and the reduction of the compensation by the learned trial court without taking note of the notification dated 1/2/2019. In the opinion, cannot restrict the compensation which the petitioner is otherwise entitled to on the basis of the scheme of 2012. Considering the above, considering the instant writ petition therefore stands disposed of with the following observations and directions. Who is adjudicating this now?
This is under the Barpeta Legal Services Authorities.
A long thing. We direct this secretary. The secretary, Assam State Legal Services Authority, is therefore directed to judge on the extant facts as to whether the petitioner, first of all, the number one, the compensation which is payable to the petitioner is to be regulated in terms with the Assam Victims Compensation Scheme 2012. Read with the notification dated 1/11/2019.
1 to 2019.
1/2/2019. Number two, the secretary, Assam State Legal Services Authority, that is the respondent number
Three,
Three, madam.
3, is directed to assess and evaluate as to how much the petitioner would be and how much compensation the petitioner would be entitled to on the extant facts, and more particularly taking note of the judgment passed by the learned trial court terms with the notification dated 1/11/2019, wherein it is specifically mentioned that the compensation ranges between 3 lakhs to 5 lakhs for rape victims. On the basis of such adjudication, an award would be passed within 60 days from the date a certified copy of this order is served upon the respondent number 3. Next. That the award thereupon shall be forwarded to the respondent number 1, and the respondent number 1 thereupon shall provide the necessary finances to the respondent number 3 for onward dispersal of the amount to the petitioner. The said exercise be carried out by the respondent number 1 within 90 days,
my lord.
90 days from the date the award is forwarded by the respondent number 3 to the respondent number 1.
My lord, the fixing of quantum of compensation is as per the Motor Vehicles Act, my lord, as per clause 6 of this notification. As per clause 6 of this notification, the compensation quantum is fixed as per in terms of the Motor Vehicles Act, my lord, schedule in the Motor Vehicles Act. Fixing of quantum, my lord. So they may take note of clause 6 of this notification while fixing the quantum.
It's okay. They have said 3 to 5 lakhs. So it has to be adjudicated by them.
On the basis of this
So
notification.
that you advise your client on that.
My lord, similarly situated matter, your lordship directed to pay 5 lakhs, my lord.
I can't, because it is between.
Yes, my lord.
It is not for me to decide. Don't reduce me to the secretary of ASALSA.
My lord. Of like.
What is this?
Lordship, last occasion I was directed to obtain instruction. I did receive one instruction.
Oh, you got it?
Lordship, one of that in that cell. itu কি ফাইল কৰিব বাৰু সেইটো similar আই কি ফাইল আৰু এইটো উদ্যোগ কৰিছে ধৰণে এই হেৰিয়া ঘূৰি আহিছে আহিলে বিভাগৰ যে ট্ৰান্সফাৰ হৈছিলে আকৌ ৰিটাৰ্ণ আছে আৰু দুটাই
Mr. Mondol, are you in touch with your client nowadays?
Yes, my lord.
See the instruction which is there, you have a copy of it.
Lordship, only one copy just now I have received. Yeah, but
You have the copy for the other one. The other one is also.
other one, no, but Lordship, other one is something is similar. My last Lordship that
See, what has happened, the buyer, there was a defect as regards your buyer's affidavit. The consideration amount was not mentioned. Therefore, pursuant to the order passed by this court, this particular person was duly informed. The buyer came and that all kinds of necessary help for processing of the NOC of the land sale while submitting the application to the government as per the SOP of so and so. If he submits a new application. Now thereupon, there has to be a new application. Therefore, I asked you, you kindly have a look at this paragraph 11, 10 and reply to paragraph 9 and 11. You can look.
Section 2, executive was so mad. Which Mr. The seller missed. Application by a complaint complete on amount for
You ask this particular person, Mr. Handy, Lordship, ask him to bring this on affidavit.
This one, Lordship. Lordship granted sometime, my lord. Sometime maybe.
But
done.
there are certain assurances, then the petitioner is also satisfied.
And last page, Lordship, he was asked to, my lord, to submit some concept, my lord, that
Directs the so-and-so to furnish the list of documents to so-and-so. Have they furnished the list of documents to you?
no, lord.
By
I was-
passed the order on 15/7. In addition, this court directs the present edition to furnish the list of documents to Mr. J. Hendrick, the learned junior advocate.
Oh, that was not furnished, my lord.
Well, we ask the additional district commissioner to be present then. As in spite of the order passed, you have communicated, he is not
Lord.
furnished. It does not show in good light. Who is the additional district commissioner? Dhubri. দেখো এই দুইটা কেসত লিখিব দেই The present petition has been filed, application has been filed, alleging willful and deliberate violation to the order dated 2025, passed in WPC number 6960/2024, whereby there was a specific direction upon the respondent number 3 therein, that is, the additional District Commissioner Revenue Branch to furnish the list of documents which according to him were not submitted by the petitioner with their application dated 29/6/2024 within 7 working days from the date of submission of the certified copy of the order at the office of the respondent number 3. Evidence of the petitioner herein that in spite of the certified copy being submitted, the respondent number 3 have not, respondent number 3 in the writ petition have not furnished the list of documents. It is under such circumstances the present contempt application has been filed. This court issued notice on 30/5/2025. None of the respondents have put in their appearance. It is under such circumstances on 15/7/2026. This court requested Mr. J. Hendrick, the learned junior government advocate, to obtain instructions as to why the order dated 5/2/2025, passed in WPC number 6960/2024, have not yet been complied with. Give me that document. In the said order, this court further categorically directed the additional District Commissioner Revenue Branch Dhubri to furnish the list of documents to Mr. J. Hendrick, the learned junior government advocate, so that the same may be placed before this court on the next date. Full stop. Mr. J. Hendik have placed before this court an instruction issued by the District Commissioner Dhubri. This court put a specific query upon Mr. J. Hendik as to whether, in compliance to the order dated 15/7/2026, the Additional District Commissioner, Revenue Branch Dhubri, have provided the list of documents to him. Full stop. He therefore, Mr. J. Hendik therefore submitted that no such list of documents have been furnished. Considering the above, it therefore appears furnished. Full stop. On the Mr. J. Hendik further places before this court an instruction so issued by the District Commissioner. Oh, this is there. Why you are saying not there? This is the first document.
Lordship, it was.
Mr. J.
Sorry,
Hendik. You don't read your instructions also.
Morning I have.
So the contempt is dropped. Kindly see this, the
Lordship.
first page. I'd like to inform you that the buyer's affidavit which was uploaded in the Seva portal along with the NOC for land sale permission. Consideration amount was not mentioned, thereby the affidavit became an incomplete. This is the list of document.
The second or also is
Mr.
I'm sorry, Lord.
Officers would think that this court have not looked into it. Luckily, I turned the page.
12 by 10.
You'll give you now, but the complete instruction you'll get. Itu agote na. And this court I to 15/7 order to legal huh? In pursuance thereto, Mr. J. Hendik, the learned junior government advocate, has placed before this court an instruction issued. The parawise comments issued by the District Commissioner, Dhubri, dated 3rd of August 2026. Along with the said parawise comments, the list of insufficient documents was also furnished as Annexure A. From a perusal of the said document, it is apparent from the perusal of the said list of document enclosed as Annexure A. It is mentioned that the buyer's affidavit which was uploaded in the Seva Setu portal along with the NOC for sale, land sale, permission application, consideration amount was not mentioned, thereby the affidavit became an incomplete document. The instructions along with the enclosure, which is the list of documents, insufficient documents, are collectively kept on record and marked with the letter X. Taking into account the above, it is the opinion of this court that nothing further remains in the instant proceedings to be proceeded with, for which the proceedings stands dropped. The petitioner would be at liberty. Mr. J. Hendik, the learned counsel, the courtmaster of this court, is directed to provide a true copy of the document which is marked as annexure with the letter X to Mr. M.U. Mandal for necessary for doing the needful.
Attempt 12.
Same.
Say, my lord, that there is the list of document, I know, my lord, that seller
List of the
amount
annexure
is
A
not is there, and now, my lord,
the
that.
seller's
of the-
name was found mismatched.
Lordship.
It is Silobhat. Have listed documents have been given. Annexure A will go, wherein it was mentioned that the seller's name was found mismatched with the land record and the application and name correction affidavit was not submitted. In addition to that, the affidavit by the buyer was incomplete as the consideration amount was not mentioned therein. Marked and kept on record and marked to the letter. Mr. Henry, the excuse is very lame because of the fact, if you know how applications are made, nobody puts the value because the value is normally put by that particular officer after the assessment is being made. If you know how the land sale permission is taken out. Isn't it, Mr.
Yes.
Obliged.
Obliged.
You can drop the.
Worship, in this case, service is complete and respondent number 5 has filed wakalatnama, the private respondent.
My lord, I am appearing for respondent number 5.
Yes, what is your case?
Worship, this is a challenge to an order passed by the Board of Revenue, your lordship.
Hi.
And I have been told that there is a scope of settlement as well. The parties want to go for a mediation. They are family members, your lordship.
Huh?
They're family members, the private respondent and the,
Now what do you want?
there is a scope of settlement between the parties, as I have been instructed by as I have been informed by the respondent, your lordship.
What is wrong with the order?
Lordship, in the order, in fact, I am the granddaughter of the respondent number 5, your lordship. My name was inserted in the Jamabandi without any notice. My name was struck off by the circle officer. I preferred an appeal before the district commissioner, your lordship. District commissioner inserted my name. Against that, the private respondent approached the Board of Revenue. Board of Revenue, in that application, in that appeal, your lordship, has enlisted all the family members, all the other legal heirs of the deceased person, and determined their share as well. Most of whom have already relinquished their right or sold those portions. And there is another civil suit also pending, filed by the private respondent, your lordship.
It is categorically mentioned. It is clarified that this order is passed only for the purpose of mutation
Mutation.
in the revenue and shall not be construed as a declaration of title or final share which shall abide by the decision of the competent civil court.
Those persons, your lordship, whose rights were declared by the Board of Revenue were never in the possession of the suit land. Most of them have left the suit land long back, your lordship. They were never, they are the daughters, married daughters, and some of them have sold their
So
share
is
as
it
well,
required? Isn't it the ownership? Are they not co-owners?
lordship, but they were never in the possession, your lordship.
Huh?
They were never in the possession,
So what?
and their names were
Isn't it
never,
the possession of a co-owner taken as the possession of the everybody?
lordship.
That's the law. Is it your case of adverse possession in the partition proceedings? Then what is wrong? We dismiss your petition.
That apart, your lordship.
No case. I think dismiss. What do you say?
That,
Dismiss.
that apart, your lordship. Another contention of the petitioner was that it was a self-acquired property of the father of the petitioner, your lordship.
So that is the matter which is pending before the civil court. So that you are agitating. So what is wrong with this order?
Civil court,
We will only say that to their effect. This declaration is categorically being mentioned. You see, they have what they have said. Kindly see the order. The impugn order dated so and so is set aside. The revenue records pertaining to what so and so shall be mutated in the names of all the rightful legal heirs of so and so, as indicated in the conclusion above in accordance with inheritance. Therefore, all previous mutation orders as legal heirs of so and subsequent mutation orders and consequential partitions are set aside. It is clarified that this order is passed only for the purpose of mutation of the revenue records and shall not be construed as a declaration of title or final share, which shall abide by the decision of the civil court. Then, what is there? Fantastically drafted order. Why should we exercise 2 to 6?
Yes, you also mentioned, lordship, this mutation shall be subject to the final adjudication of the title.
But I have been reading all along. So, fight it out. Already a suit is pending. Then, you don't want to share the amount. Mutation is what? Only payment of revenue. Now everybody wants to pay. Now you want to say that no, I will only pay. So, Here it is clearly mentioned. You want a further clearance or stamp of authority by this court saying that whatever may be shall be subject to the outcome of the civil suit. That's all. Conclusion. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr.
As per Nikhil.
State of Assam, 1, 2, 3, 4. One, two, three, and 4. And how many legal aids are there? Of so-and-so. And who are you?
I am the granddaughter, your lordship,
Of?
of the
Original
respondent number 5, your lordship.
Respondent number 5.
And what about the other people not made parties here?
Because they were never a party before the revenue court, and
So what? Everybody's rights are involved. Isn't it the direction? How many people were there? All the legal aids. Or the so-and-so appears on behalf of the respondent number 5. Writ petition has been filed by the petitioner assailing the order dated 4/2025 passed by the learned Assam Board of Revenue in 6 bracket RA bracket 6 RA bracket L oblique 2023, whereby the order dated 16/7/2021 passed by the additional deputy commissioner bracket revenue Lakhimpur in miss case number 6/2020 was set aside 20, and the subsequent order dated 2/9/2022 passed in partition case number LAK UTT 2022-23 24869 OPART were set aside. And further, it was observed all the rightful legal heirs of late Ram Lakhan Singh would be entitled to have their names mutated in the record of rights in respect to a plot of land at measuring 3 Katha 11 lechas covered by Dag number 727 bracket O oblique 3112 bracket N and Patta number 575 bracket O oblique 1658 bracket new of under North Lakhimpur Revenue Circle in the district of Lakhimpur, Assam. The learned Assam Board of Revenue, number 19C, clarified that the order so passed was only for the purpose of mutation in the revenue records and shall not be construed as a declaration of title or final share, which shall abide by the decision of the competent civil court, wherein title suit number 12/2023 is presently pending. This court had perused the materials on record as well as the directions so passed by the learned Assam Board of Revenue in the impugn order dated 10/4/2025 and is of the opinion that the impugn order do not require any interference in exercise of the certiorari jurisdiction of this court, inasmuch as there is no error inasmuch as this court does not find the said order to be erroneous requiring the interference of this court under Article 2 to 6 of the Constitution. Accordingly, the instant writ petition stands dismissed. Pusto. Before parting with the record, this court observes that taking into account that a suit is pending before the learned court of the civil judge Lakhimpur, not Lakhimpur, being title suit number 12/2023. The decision, the order impugned in the instant proceedings shall be subject to the outcome of the said suit.
May please your lordship. Lordship, service upon private respondent number 10 is complete through dusty mode, lordship.
What matter?
ISA carton covered my.
Covered?
My.
এইটো আমি এটা খুদি দিব এটা আমাৰ এই ছোৱালীজনীৰ নামটো কি আছে শিৱানী কৈ দিব এইটো শিৱানী বা এই কাৰোবাক কৈ দিব disposed.
Authorized, lordship.
You are?
MM Zaman, lordship.
I know. You are the candidate who have been disqualified.
Yes. Removed, my lord.
So your petition is allowed.
Yes. Obliged, lordship.
শিৱানীক লিখিব দিব। Yes, what is your case?
Your lordship, notice upon respondent number 4 is complete as per the Lavazima court order.
Case.
The matter pertains to, your lordship, non-registration of the FIR, your lordship.
Huh?
Non-registration of the FIR.
What?
There was a FIR which the petitioner filed before the officer in charge Vasistha police station, but it was not registered. So later on, the petitioner filed several representations, and lastly on 19/4/2026, the petitioner filed before the Deputy Commissioner of Police, and they have filed their reply also, your lordship.
Never reply. Why should we entertain?
They have stated that they, as per section 1,
What has happened to your land?
that the title suit is going on, your lordship. And the next stage
What
is,
suit you have filed?
that is not on record, your lordship. I have the certified copy.
Huh? This is an inaction on the part of the respondents for registering an FIR
For non-registration.
or non-registered. Therefore, I use the word inaction
Yes, yes.
for not registering FIR. So, what should I do? Go before the jurisdictional magistrate.
They have approached before the jurisdictional magistrate, your lordship.
And what happened before the jurisdictional magistrate?
It's pending, your lordship.
So, am I sitting out here under 2 to, can I 2 to 6 exercise jurisdiction over the jurisdictional magistrate? You should have then moved under whatever the applicable sections are under the B, N, and S. Under revision. Earlier sections are 397 or 401 or 482. Why are you here? We have no business out here to trouble the state on this. Closed? Withdraw? Liberty? To file? You move the jurisdictional magistrate.
We have more because there's some non-cognizable offense, lordship. So we have filed one application before the magistrate for seeking permission for lodging the FIR.
It's okay. I'm not on that.
Yes.
My question is, if anything is happening, if you are taking certain steps,
But two-
where have you moved the jurisdictional
Yes.
magistrate?
That is page 145 of our affidavit, lodge.
145. To the Honorable Chief Justice, submission of preliminary inquiry and prayer for permission to proceed under suit. How are you going to do the matter? Should I dismiss it in your hands or in your senior's hands? Senior's hands also today only, not tomorrow. It doesn't go for tomorrow. No, you say that you have moved the jurisdictional magistrate. Where?
No, Your Lordship, they have moved before.
So they are doing it. That means they are doing more than what is necessary.
Lordship, they are saying that it's a non.
So you have not moved. Go and move there. Okay. I have heard Miss So and so, the counsel appearing on behalf of the petitioner. Mr. N. Goswami appears on behalf of the respondent numbers 1, 2, 3, 4.
Not 4, Lord.
I know
My name here.
that is 5. 5 is by name. 4 is officer in charge, Bokhisto Police Station. 4, 6, and 7. The present writ petition has been filed by the petitioner being aggrieved by the inaction on the part of the respondent authorities in registering an FIR in registering the FIR so submitted by the petitioner, and further carrying out the investigation thereupon. First, this court duly takes note of that on 11/5/2026, notice was issued on 11/5/2023. On 18/5/2026, notice was issued by this court. The respondent number 7 has filed an affidavit on opposition. Wherein it is mentioned that as the complaint of like FIR dated 6/4/2026, wherein it is mentioned that upon receipt of the complaint dated 6/4/2026, a GD entry number 49/49 dated 6/4/2026, an inquiry was a GD entry dated here was inserted, was made, and an inquiry under section 175 bracket 3 bracket small 1 of the BNSS 2023 was directed after obtaining the approval from the competent superior authority, namely the ASCP, Bokhisto. It is further mentioned that the sub-inspector was entrusted to ascertain whether the allegations disclose commission of any cognizable offense, warranting registration and investigation. During the course of the inquiry, it revealed that the dispute substantially related to possession and rival claims over landed properties. It is also mentioned that simultaneously an inquiry, and it was also mentioned that the inquiry also disclosed that simultaneously the allegations attracted section 115 bracket 2 of the BNS, which is a non-cognizable offense. Consequently, in compliance with the statutory mandate, the petitioner was informed by communication dated 24/2026 that the respondent number 7 could not proceed with the investigation of a non-cognizable offense without the permission of the learned jurisdictional magistrate Kamrup Metro. In addition to that, the inquiry officer submitted a petition dated 22/4/2026 before the learned Chief Judicial Magistrate Kamrup Metro, seeking permission under section 174(2) of the BNSS 2023 to proceed with the investigation of the non-cognizable offense. The matter is presently awaiting appropriate orders from the learned court. Posto. The said applications so filed as well as the said applications so filed before the Chief Judicial Magistrate Kamrup, before the learned Chief Judicial Magistrate Kamrup Metro have been enclosed as Annexure B to the said affidavit. Posto. Taking into account the above, comma, and this court have all duly, and this court have heard the learned counsels appearing on behalf of the parties, BNS, BNNS. Taking into account the, and have also perused the materials on record. Ekon নহয় নে? The grievance of the petitioner herein is that the petitioner, having submitted a complaint before the respondent number, four on 6/4/2026, having submitted a FIR on 6/4/2026, and subsequently no action was taken for registration of the said FIR. And it is under such circumstances the present petition has been filed. Court duly takes note of that section 175(3) of the Bharatiya Nagarik Suraksha Sanhita 2023 is parameter to section 156(3) of the Code of Criminal Procedure 1973, whereby the petitioner has a statutory remedy to approach the jurisdictional magistrate. This court finds it pertinent to take note of the judgment of the Supreme Court in the case of Sakira versus State of UP reported in so-and-so, where the Supreme Court had categorically observed that the exercise of jurisdiction under Article 2 to 6 of the Constitution in matters of the present kind ought not to be entertained. In view of the availability of the remedy in terms with section 156(3) of the Code of Criminal Procedure 1973. Considering the above proposition of law, as well as also the stand which have been so taken by in the affidavit filed by the respondent number 4, this court is of the opinion that the present case is not a fit case for being entertained under Article 2 to 6 of the Constitution. Accordingly, the writ petition stands dismissed. Before parting with the record, this court, however, observes that the dismissal of the instant writ petition is on the ground of the same being not entertained. And under such circumstances, neither of the parties to the present proceedings, and under such circumstances, the petitioner herein shall not be prejudiced in any future proceedings in connection with the allegations so made. So in addition to that, the petitioner would be at liberty to approach the concerned jurisdictional magistrate if so advised.
Lord, this case is also covered, my lord, but negatively, my lord. Negatively covered.
Negatively covered. He is
I'm for the petitioner. He's
he
seeking
is the other
direction.
one.
He's seeking direction, my lord, for private respondent shall be removed under this section.
It is the other one, the
Well, in Aisha.
no, Aisa is different.
Firdausi one.
The other one, the next one, the
Firdaus
Firdaus.
Firdausi Roman.
This will cover the Firdaus one. Chalo. Dismissed. এখন কৈ দিব হা নাটক কৈ দিব উল্টা নামবোৰ লৈ ল'ব give your names oh what has happened this
May I please, see, this is your lordship's earlier order is at page 161.
so you approached the ombudsman
Yes.
after that
we
what
did.
happened there
They have not decided in our favor. We are before your lordship now.
they decided
Yeah, that is at page 164.
now what has happened
We have challenged that we are before your lordship. I think the respondents have all been served and there should be the insurance company is appearing. You? Insurance company, you are want to take time or something till.
now what has happened who has filed the affidavit
Lordship, I'm appearing for respondent number 3 to 5, Lordship. We are appearing for the first time. We need 3 weeks time to file our affidavit. The insurance company.
so now we have to take it on merits
Yes.
and who is appearing for the insurance regulatory what is your stand then your stand will be relevant
I'll file my instruction, although your lordship, I am not a formal.
the mic there is a proper mic given on the side yes
I am only a formal party, your lordship.
no you are
I
not
will-
the formal part
Because I'll raise the objection in the online portal and thereafter it will be solved by the insurance company.
these policies which are there is based upon your regulations.
Regulation, yes.
Therefore, what they are doing is permissible as per your stand. That is the important thing.
So therefore I'll
That
file
is
my
the-
affidavit.
Therefore, you are to bring your stand on record because they would obviously say, no, we are not, because it is a case within 180 days, this has been discovered.
Yes.
It is not entitled to this. But the fact remains that there was a earlier policy also.
Policy.
Yes, my lord, that is continuing.
It's a continuing. So therefore, in your, as per you, whether he is entitled to not, you file your affidavits quick because this is a case of which requires urgent thing.
Yes, my lord, because his
When
treatment
are you
is on.
filing your affidavits? Both, you also.
2 to 3 weeks. Within 2 weeks.
Because he
We have,
has problem otherwise to finance his health.
yes, absolutely, but, and we have continued to pay, they are accepting.
You are not a formal party, Mr. Dutta. Very clear to you. Your stand is very relevant out. Because it is because of your stand. We are to, whether they, because of your regulation, whether they are acting as per your regulations.
Their own conduct will not, there was a delay of 3 or 4 months. 2 months. And they are continuing thereafter also to receive. That was in 2024. We are to pay by June. We paid in August. They accepted. There is no difficulty. And giving the receipt, the next installment as per the earlier policy minute, it is 15/6/25. We paid. Again, 15/6/26, we have paid. They are accepting. Your lordship's last order in that matter will come to our aid. No? And the diagnosis came in December of that 24 minute, after we have paid the duty, insurance company. Page 50, if your lordship sees the lapse clause.
Mr. S. Dutta appears on behalf of the respondent number two, union.
I'm for the union.
So appears for the respondent number 1. Mr. S. Dutta appears for the respondent number 2. And so appears for the respondent number 3, 4, and 5. For the purpose of adjudication of the present proceeding, the presence of the respondent number 6 is not necessary. Therefore, the present proceedings can be proceeded with in their absence. The petitioner who is suffering on account of being inflicted with the ailment cancer is aggrieved by the repudiation of the petitioner's claim by the respondent number 3, 4, and 5. The petitioner initially approached this court by filing a writ petition, which was registered and numbered as WPC number 866/2026. However, this court, taking into account that the insurance ombudsman would be an appropriate forum, relegated the petitioner to approach the insurance forum with a further liberty to approach this court in the circumstance the petitioner is aggrieved by any order passed by the insurance ombudsman. Pursuant thereto, the insurance ombudsman passed an order on 24/3/2026, whereby the repudiation of the claim by the respondent number 3, 4, and 5 have been upheld. It is under such circumstances the petitioner has approached this court. The petitioner herein have questioned the manner in which the claim of the petitioner have been repudiated and repudiated, as well as to whether in in the extant facts, the respondent number 3, 4, and 5 could have repudiated the claim. The respondent number 2 regulates the various insurance companies in terms with what is the provision? Insurance regulatory? Huh? How do you regulate?
129 we have given the master.
In terms of the Insurance Act. In terms of the Insurance Act. Under such circumstances, as to whether it is permissible on the extant facts for the respondent number 3, 4, and 5 to repudiate the claim of the petitioner is an aspect which needs to be repudiate the is a question which is before this court. The stand of the respondent number 2 would be very relevant, apart from the stand of the respondent number 3, 4, and 5. Considering the above, this as there is an urgency shown in the instant writ petition, and this court fixes the matter again on 27th of August 2026. In the meantime, the respondents numbers 2, 3, 4, and 5 shall bring on record their stand by filing their affidavits on or before 21st of August. 21st of August 2026. Liberty given to the petitioner to file reply thereagainst. An attempt shall be made to dispose of the writ petition on the next date. Liberty given to the parties to mention the matter for upgrading.
May it please your lordships. Lord, as per the directions of this honorable court on the last occasion, Lord, we have deposited the amount along with the 9% interest as has been ordered by your lordships, Lord, before the Registrar General.
Now, what is your case?
Lord, at this stage, my prayer would be to grant us some time to file reply to the affidavit filed by the private respondents, my lord. That is respondent number 2 to 7 to 47. Seven to 42, man.
Respondent number 2, you are there.
All India Limited, yes, your lordship.
You have filed your affidavit.
1 and 2, we have filed our affidavit also.
You have given the details of the compensation which is worked out.
Yes, lordship.
What are the details of the compensation worked out? As per
90
your affidavit, which paragraph?
If your lordship will come to page 93. There are 3 different components of compensation that we have paid. The initial one, if your lordship will come to.
Yeah.
Just a minute, lordship. Page. At page 92, if your lordship will see, this was the initial communication. The first amount that was paid was 94,70,670. That was for the surface compensation. That payment document, lordship will find at page 53. 53 is a part of the stay vacating application. That document is annexed there, lordship. Yes.
What?
The first payment is 94,70,670.
No. First of all, you're referring to some other pages. Page 53
Yes, lordship, the
is a
document,
part of the petitioner's document.
it's a part of the stay vacating application that was filed by one of the private respondents.
When
That-
you're referring to the stay vacating application, my question is, where is the document where you are to refer it either in the writ petition or in your affidavit? Have you mentioned that? My question is that.
Yes, lordship.
The affidavit starts from which page?
Starts from page 65, lordship.
Where?
At page 117, if your lordship will come, lordship will see one of the payment for rehabilitation grant, page 117.
Is there a declaration?
Yes, lordship. The description is there, lordship. In the description,
Being the managing director is managing the entire affairs of the garden of so and so, so I do hereby undertake and agree to indemnify the Iman claim so and so, which may be raised against or incurred by the Oil India Limited by reasons of deposit of so and so. So this is 7 crores.
yes, lordship. The other payment,
Have this payment been made of 7 crores?
entire payment has been made. This is,
Where is
against
it?
rehabilitation grant.
Where? Rehabilitation grant is for 40 bigas.
Yes, lordship.
It's for 40 bigas, no?
Yes, lordship.
40 bigas. 7 crores,
40 bigas, yes, lordship.
84 lakhs. 2 lakhs 84,000.
Yes, lordship. The next payment, details your lordship,
How did you take this amount? Means,
by,
what is,
by demand draft, lordship.
understood.
Yes.
How did you pay to the respondent number 5?
Because the respondent number 5, by way of an agreement with the Karta, was managing this garden. And I think there is no dispute to that regard. In so far as the other co-partners, 35 co-partners are concerned, they have agreed to that aspect that he was the authorized person. And there was a communication also made to oil that it can be paid to him. And accordingly, money was paid.
Now, where is that communication?
Today, actually, lordship, the matter had come for that compliance. So,
It's a different thing.
yes, lordship. If I may be just-
Now, once the petitioner have returned that amount,
Yes, lordship.
petitioner gets his locus because his challenge is on another land, which is not a subject matter of the writ petition. If you see his prayers, he has 3 prayers. First prayers, look
Yes,
at
this-
his prayers.
His case is basically regarding that.
No, his case is something more like a Right to Information Act. Okay.
Correct.
Number 1, page 18.
Yes.
Respondent number 2 to declare to the petitioners about any amount of compensation which still remains to be paid against the land acquired by the respondent number 1.
Yes, lordship.
So what is the remaining compensation to be paid to the respondent number 1? Acquired by the respondent number 1.
Respondent number 1.
Okay.
So the money. Yes.
So this is an information he's seeking.
Information that he is seeking.
Second, a writ in the nature of mandamus directing the respondent authorities, more specifically the respondent number 2, to declare to the petitioners about any amount of compensation
Yes.
which have been paid and to whom with regard to the land acquired by the respondent for so and so. This is also an information which is seeking. So you say that an amount of rupees 7 crores have already been paid on account of rehabilitation for 40 bighas of land. That is. Now, what is remaining to be paid is whether that information is available in your affidavit.
Yes.
Number 2.
Come to
Wait.
page 266.
Number 3.
Yes.
Be it in the nature of mandamus directing the respondents to complete the payment of the entire compensation amount to the rightful owners of so and so over the land acquired by the so and so. Now the third line, the third prayer
Prayer.
is that the payment of compensation is to be given to the rightful owner. If you have made the compensation, it is not a case of acquisition under that act. It is a case of an outright sale and
Bipartite
certain
settlement.
payment of compensation on account of rehabilitation. One amount 7 crores and the other two amounts, one is by way of purchase.
Yes. One is surface compensation already paid, 94 lakhs. It is agreed that the payment has been made. It is only regarding the distribution aspect where the dispute is coming as to who has got how much.
Then a
And the-
reader directing
and the-
to stop utilizing this order cannot be passed if the land have been acquired. Now, are you utilizing prior to the writ petition? The land?
Yes, Lordship. After the agreement has, your Lordship will come to page 269. There is an agreement for sale. After that, we are using this land, Lordship. Agreement to sale at page 269. Wherein at serial number 24, the petitioner is also there. And as per this agreement, the amount that has been ultimately agreed was further 7 crores, out of which when this agreement was signed, 50% of the same has been paid.
So they have agreed to sell 39 bighas.
Here, 39 bighas, 4 kathas, 11 lessas. 9 lessa differences.
Less than the rehabilitation.
Rehabilitation, yes, Lordship. And as per this agreement to sale, the amount that has been accepted by all the parties was 7 crores, 1,22,000, out of which 50% has been paid, and that Lordship will find at page 274.
And 50% you have paid.
50% I have paid. Page 277, the demand draft number is there in the agreement itself. Page 277 at the top portion, Lordship will find.
Where the petitioner is a party.
Serial number 24, signatory by way through the power of attorney holder, Babul Sonowal, which is again under any dispute, Lordship. My case is this. My case is that after there has been a consensus among the parties, I have paid 2 components as compensation. One is for surface compensation. The other is rehabilitation grant. And thereafter, there was an agreement for sale executed by all the co-pattadars along with All India Limited for 7 crores, 1
And
lakh.
how did you pay? Was there any agreement for the surface rehabilitation?
That, Lordship, that details I do not have in my affidavit. But
Why did you pay it for surface compensation, rehabilitation?
that was a requirement, Lordship. The Lordship will take it up tomorrow, and I'll be better prepared with that, because the entire aspect is basically what the payments were made. There is no dispute regarding the payments being made.
His entire case is that payments, there is no disclosure of the payments made.
No disclosure, but
The different thing that Mr. Das today comes up and says that why that Petroleum Act have not been invoked.
but that is not the case in the pleadings of the writ petitioner, number one. Number two is that she has herself walked into this agreement, this bipartite agreement or agreement for sale through the power of attorney holder. Having entered to that aspect, now there cannot be a walk back to the original stage saying that, no, I don't want to go ahead with this agreement of sale. Because the agreement of sale is still on record. It has not been interfered by any court, or neither that he is withdrawing from it. She is withdrawing from it.
And the power of attorney have been revoked when?
Lordship,
When has the power of attorney been?
that information I do not have, Lordship. This is what
Yes, Mr. Das, when have you revoked the power of attorney?
It's there. I'll just give the date. Maybe.
Agreement entered into when, Mr. Sharma?
22/5/24, my lord.
22/5/2024.
24.
How?
That details, my lord, it's not there in
No,
the.
no, it has to be by a registered.
It was,
document.
my lord, yes,
Whether the power of attorney which was there was a registered document?
it was, yes, my lord. It was irrevocable general power of attorney, my lord,
It's a registered document.
registered, my lord.
So
And
if it is a registered document, you have to,
there is a communication.
no.
Yes, my lord.
No. The count. If it is a registered document, you have to revoke by a registered document.
Yes, my lord.
Have you registered it?
Yes,
Revoked
this-
it by a registered document.
Yes, I have revoked all the powers, so and so, so and so. They have registered another deed, my lord. That cancellation deed.
Where?
My lord, the deed is not in the records, but the communication page 283 is there.
Page?
283. Page 283 is the affidavit by oil.
no.
No, my lord.
Affidavit by oil ends
No,
prior to
sorry.
that. 283, yes.
283, affidavit by oil.
Yes, Lord.
Lord, one aspect I'd like to clarify before your lordships, my lord. There should not be any mix-up of facts with regard to, my lord, this power of attorney and the release of rehabilitation grant vis-a-vis the surface compensation, my lord. These two are different aspects, my lord. My learned brother is making a submission.
This is a person, this is written by some Vikram Sharma.
Vikram Sharma, who was the my lord, another person who earlier instituted a writ petition. My lord, he was the person.
That has no relevance.
My lord, so far as
That
my
petition has been withdrawn. That petition has been withdrawn.
I understand. My lord, same thing in our case also same. My lord, cancellation of deed power of attorney is
There
there.
is the document.
My lord, that document is not part here, my lord. That
Then
my lord, in fact, my lord,
you don't know the number of the document. You don't know the number when you have revoked the power of attorney.
my lord,
And
we have
the agreement was entered into, agreement for sale was entered into when?
the agreement of sale of entered into on, my lord,
10/4/24.
2024.
And 4/24.
And this was after that.
Huh?
The revocation was
Has
in
to
the month of May. Agreement was entered in the month of April. Revocation is in the month of May.
Revocation by how?
If at all it's a revocation in the eye of law by this document, then that also happened in the month of May. So on the day when the agreement was signed,
So the doctrine of holding out will apply. So that is okay. And once the payment has been made
yes, Lordship.
to the power of attorney holder
Yes, Lordship.
of rupees 3 crores, when did you pay that amount? 3.5 crores?
On Lordship, by demand draft dated 22/3/2024.
Before the agreement.
It was paid along with the agreement being done. The
Because
draft was made
you
on.
say the agreement is on 10/4/2024.
Yes, Lordship.
Then why did you pay it earlier to that?
No, not paid earlier.
Then-
The demand draft was made. The demand draft was made on 22/3/2024, and it was paid along with the signing of this agreement for sale. That is already there in the agreement itself.
Okay, so therefore, the
addition is there in the
payment
agreement
was-
itself.
and the demand draft was given to the owner, to that power of attorney.
To the power of attorney, yes,
So
Lordship.
therefore, the doctrine of holding out will apply. He cannot go by against that. That is going
Yes, yes,
no way out after this.
yes.
So the second amount
second amount would be that amount of 7 crores, Lordship.
The amount of 7 crores which is being paid, the rehabilitation grant, because you are normally purchasing the garden,
Yes,
the 40 bigas.
yes, 40 because we're purchasing that.
Then why you are paying the rehabilitation grant?
Maybe there is some requirement under law that I am not been able to apply the lordship as of now. But this amount has been paid, therefore there must has been something.
Understood. You see, a right will accrue upon the petitioner on the basis of, you see, you are purchasing normally what happens? You don't purchase anything.
Yes.
You go out there, ask the authorities, assesses. Ground compensation, surface compensation is only paid on the value of the land. That's all, nothing more than that. But here you are paying a higher amount than the surface compensation.
Surface compensation only 94 lakhs. 94 lakhs
No,
70,000.
Yes, so that is, so therefore what you are doing is you are purchasing that land.
Yes.
You are purchasing the land. Once you are purchasing the land, you have a right over the land.
Yes, Lordship.
That 40 bighas of land, you have a right over the land. You are purchasing.
Purchasing, yes.
It's a different thing that the permission have not been accorded.
After the agreement to sale, permission is not accorded because of the disputes.
No, not because of this, because it's a T-patta. It cannot be converted like this. There cannot be an outright sale. You need the permission from the government, isn't it? Isn't it, Mr. Wolhende? You cannot purchase it like this. The permission of the government, T-patta land, if you are selling it or purchasing it, the permission cannot be by the district commissioner or anybody. Has to be by the government.
Lordship.
So therefore, you are not getting the permission because purchasing this is not permissible normally. But you have fought for doing so.
At paragraph 13, page 70, we have otherwise specified as to how the process has gone ahead. Page 70, paragraph 13.
The settlement document which they are claiming from very beginning, bipartite, that is not also part of the record.
Our stand is at paragraph 13 as to how the process has gone ahead insofar as taking over this land is concerned through this bipartite procedure. But Lordship, yes, that procedure is not on record in these pleadings, that bipartite settlement procedure. But then this has been followed with the consent of all the contesting parties here before Lordships.
How are you saying so?
Because the money has been paid.
Understood, but consent has to be on the basis of some documents.
The very fact that they have signed on the agreement of sale.
Agreement for sale is okay.
So therefore, I presume that the consent was there only, therefore they have signed.
Therefore, the agreement for sale is okay. There's no quarrel.
Yes, Lordship.
You see, therefore, what is he asking for? There are three main prayers are 1 and 2. You have to address yourself on that. One is saying, what is the amount of compensation you have fixed? Secondly, it is saying how much you have paid.
Yes.
These are these available in your documents or not? It is, because one is 7 crores, one is 94 lakhs, the other is 7 crores 1 lakh.
Yes, Lordship. That is otherwise it is
These
available.
are the three. So relief 1 and 2 is done.
Done. In
As
fact,
regards-
three also half is done.
As regards that, the payment, the third prayer, which is there, that the payment has to be made to the rightful owners.
Yes.
Now you have paid the earlier amount to him, 7 crores.
Yes.
Then you have paid this 94 lakhs also to him.
Yes.
You have paid that.
Yes.
Now, once you have paid that, my question is, why have you paid that? My question is this, why have you paid that? Because if you have to pay that, surface compensation, if you are paying, there has to be on the basis of some law.
Correct. Correct.
Now, once you have paid that, it is the duty of the petitioner, if they want, claim the money from him. You are no longer involved.
I'm no longer involved. It's a private dispute between them.
No longer involved. The writ proceedings is out.
Correct, Lordship. Correct.
You get the point? Why you are not addressing the court in that? And should I help you out in this thing? So this is the scope of the writ petition.
Lordship is exactly on the right aspect.
Now he says out here that I have paid this 36 lakhs to the petitioner. And as such, the petitioner does not have the locus. Now the petitioner have returned the money to the register to show his bona fide that he didn't know. The petitioner did not know, thought it about properties, which I don't agree. But anyway, but there be that as it may, the petitioner have returned the money. So the dispute between the petitioner and the respondent number 5 remains.
It's a private
And if it
dispute
is
between them.
remains between both of them,
Yes,
should this court entertain?
No.
Address in that manner.
In fact, that was my argument earlier also, but after that money has been returned, I
The
was.
money having been returned is
But the
to
dispute
him.
remains, the
It's
private
there.
dispute remains. It's
Who
a-
has paid the money? He has paid the
He
money
has
to
paid
him.
the money.
So he therefore said that look here, I don't have the money now, so I'm out of that. Now, if he wants the money or not, that is a different thing.
Yes.
But the fact remains that you have paid. So therefore, see the scope of the writ petition. Don't allow Mr. Das to improve on it.
I'm
He's
obliged.
trying
Lord.
to improve. So if you are asking for time, he's going to improve on it. You're not getting the point.
I'm getting a loss.
You want to do it for the help of your client, or you want to embroil your client into unnecessary litigations.
My case is, I bow down to your lawsuit, what the lawsuit said. My case is basically, I have made the required payments. It is a private dispute between the petitioners and the power of attorney
The
holder.
response number 5 had
So
on
therefore-
what basis the response? You see what has happened. This particular estate is being given to the respondent number 5 to run.
Yes, by the Kartas. That documents
Oh,
are there on
whatever
it.
may be.
Yes.
Whether the respondent number 5 on the basis of that had the power to take from you 7 crores and appropriate it to himself or itself
Yes, Lord.
and not to give it to the petition is a question which is a civil dispute between the petitioner and the respondent number 5.
Correct, Lord.
So therefore, I'm asking you, on what basis you are paying that rehabilitation once you are purchasing the garden? The rehabilitation concept will only come in if there is a requirement as per law. As per the 2013 Act, there is a concept of rehabilitation, but you are not acquiring the land. You are
I'm
though
buying.
you are acquiring, it's not a case of acquisition, it is a case of acquisition of right on the basis of a transfer by recognized under the Transfer Property Act.
Yeah.
So once you purchase it, then you have a right over the land.
Yes.
May not be to the surface. Now the surface, if it is to be paid or anything, or you are you are not going to explore there? Are you going to explore there?
We are laying pipelines there.
So you are laying pipelines, so you are not exploring also. So the government also does not come into the picture.
Yes, Lord.
So why are you paying him the surface compensation?
That why answer I do not have, Lordship.
So
But
that is the question.
what I can say is that it has been paid and received.
Because the
But I do
petitioner
not.
herein would obviously not say that don't pay.
Yes, no. He's saying I have not got my share.
Pay, but pay to me,
Yes.
not to him.
Yes. Yes.
So it is a dispute that he cannot collect it from you. His jurisdiction was only to manage the garden, and therefore he cannot collect it from you. So it is a purely civil dispute
Civil disputes.
as to whether the deed of settlement permits it. Why should this court under 2226 put its head on this?
Yes.
Amount is there. It will get the petitioner if he wins the suit out there. He will get it. Yes, argue now. Just limited scope is what?
Not, when we instituted the writ petition, Lordship has seen the records that there was no information with us. It was, Lordship is absolutely correct that this writ petition was initiated as a writ petition seeking information. After that, when they filed the affidavit, oil has filed the affidavit, my lord. Many things came out, my lord. Like not following the procedure of 1962 Act. my
That
lord.
is not your case itself.
I'm coming to that, my lord. I'm coming to that. My lord, after seeing these documents, my lord, I have already instructed my assisting counsel, because I have also seen the prayers, my lord. It's not that I haven't seen the prayers. These prayers, my lord, the projection that I was making on the last occasion or today also before your lordships, my lord, that projection does not correlate with the prayer in the writ petition. So that's why I have instructed my assisting counsel that you file another writ petition, because my instruction
See,
is
Mr.
absolutely-
Sharma, you get the point.
my instruction.
For his submission, I'm making it, what he wants now. So you want to, if you want to make the dispute bigger. it's
I would never like to make a dispute bigger. I want the land. I want the legal
Therefore, if
title
you
over
want
the
the
land now,
dispute
having paid the money.
become bigger, you can very well. But the fact remains that this is what is going to come up.
Because
Lordship is
my-
much more experienced than me.
But I can get what Mr. Das is saying.
my instruction with Milord after discussion with my client also, Milord, money is not a factor, Milord. Whatever has been done, that should, since we have got a Milord very specific and to the point act, laying down procedure, how has to be done, everything is there. So
No, Mr.
this
Khan, no,
office-
you,
I'm sorry.
you have a big problem there. You see, you had admittedly given a power of attorney. You have given a power of attorney to say somebody. This power of attorney, on the basis of that power of attorney, an agreement for sale has been entered into. You say that that power of attorney subsequently have been revoked. Whether it can be revoked by another power of attorney or any revocation unilaterally is another thing, more particularly when the power of attorney on the face of it is an irrevocable power of attorney where an interest is given. That is another thing. But the fact remains that prior to your revocation, the agreement has been entered into. Once the agreement is entered into, if you go by the principles of holding out, you are bound by that agreement. Okay. Now, once you are bound by that agreement, you cannot now come out unless you challenge that agreement in a civil court. So you need to challenge that agreement in a civil court to that effect, whatever may be, that power of attorney is illegal, whatever may be, I have revoked this power of attorney, this cannot go on, declaration, whatever may be, that can go on. That is one aspect. Now, here is a case of, therefore, sale of the land of 40 bighas, 39 bighas or so and so, where you say that you have a share of that. That's your share of that, because you are a co-owner of the entire garden of which 39 bighas is being taken over. Now, the second aspect is pertaining to surface compensation. If you go as per the Petroleum Act, there is no requirement of purchase. What is being paid is only the right of way, and which amount is much, much less.
10%. It says 10%.
And this right to fair compensation, nothing applies. So what is your right? Your case is, he has received 7 crores. Mr. Das, he has received 7 crores. He is a person who could not have received the 7.2 crores. 7.02 crores on the ground that he has been only asked to manage. So the rehabilitation grant should be given to you. You have a right on that. One. As regards the surface compensation, he has agreed into this 94 lakhs. Or rehabilitation, he has agreed into 7.02 crores. So you have a base of 94 lakhs and 7.2 crores, which cannot come down. No, it cannot come down now. Because once these 94 and 7.02 crores are there, you have a right to claim against him for your share from him. That's point number 5. So, if they have agreed with him, it cannot come down below. It cannot be 94 and then 91, 94, 92. It has to be 94 or above. If you question his right to enter into an agreement with the respondent number 2.
The two aspects, my lord. so far as this agreement to sell and power of attorney vis-a-vis revocation is concerned, my lord, I am not addressing on that point because of the reason that it's an admitted factual position that we entered into an agreement to sell with Babul. My lord. There is no doubt about it. Out of that proceed 3 crore 50 lakhs. First 50% of the entire amount, 7 crore odd lakhs was determined. 50% was paid to Babul Sonwal. Last occasion also, it was my categorical submission before your lordship that we are not concerned. I am not addressing on this 3 crore 50 lakhs. We are not disputing. We may get it from Babul Sonwal also.
No, my question is, therefore, my question is, if that is the amount which you could have got 7 crores,
This, my lord,
my question is 7 crores. First of all, it is not your case why the act was not invoked.
No, my lord, I'm saying, my lord, now we are discussing what will happen after my, because I am contemplating, my lord, it's my instruction that we'll come up with a writ petition.
You come, it's a different thing.
And if
It's a
if in
different
the
thing.
2
You,
weeks-
you may come, whatever may be. But my question is, as on date, your petition does not survive because of the information which they have already provided. One, the payment as regards compensation by them, they say that we will make the payment as per the agreement.
No,
Because
this-
the agreement, unless that agreement is not set aside.
No, agreement is, my lord, agreement is. a
No,
different
no,
aspect.
Mr. Counsel. No, you have to understand. 94 and 7.02 have already been paid to respond number 5. So therefore, there cannot be a payment by them to you. The payment has already been given unless you show that apart from sale of the property,
No, they can pay to a manager also.
that is a case visually
Look,
him.
well, I am not.
No, no. So
my-
therefore,
my-
you
my
show.
direct submission.
No, no. My question, therefore, is you are questioning and entering of an agreement by him with them.
Asking many questions, my lord.
You can't ask so many questions. That is beyond what it is.
My lord, I am in total agreement with your lordships, my lord. That's why, my lord, at the very inception, my lord, I made a submission that we are filing a writ petition, my lord.
You file. I don't take up the repetition freshly.
Not only.
As I'm bench 4-5.
Only,
By the time, before that, let me dismiss your petition now.
my lord, may not be inclined, my lord.
Yes.
My humble.
I'm not going to go into any other thing. Only the information which they have provided in their affidavit. Not otherwise. You say that you want to file an affidavit against respond number 5. These are terms I'm not looking into. Only this is the prayer and this is your what they say. Matter over.
My lord, prayer number 3 in some portion survives, my lord, that you pay to the rightful owners, my lord. That is.
No, so therefore, show me that after selling it, after entering into an agreement for sale for the same land.
What about the first two? 94 and
Understood.
7?
Therefore, I'm asking you, show me that apart from purchasing the land, oil is bound to pay you rehabilitation as well as surface compensation. Show me that.
So far as
No,
compensation.
no, no. Oil has paid more money. It's a different thing. I'm not concerned. No, no, Mr. Counsel, you show me that oil after purchasing the land is liable to pay surface compensation as well as rehabilitation. Show me.
Nowhere, they are nowhere saying in their affidavit that they are purchasing the land. They are saying we are acquiring each and every line they are saying. We are acquiring the land.
agreement
One
is on
second.
record.
What is this agreement for sale?
The agreement is on record.
That's why I'm saying they are following a mixed type of procedure.
It's not a mixed bag. They are paying more to these people.
No,
Actually, we are on the question of there is no this. Show me that there is a requirement of payment of surface compensation or rehabilitation after having paid that amount.
for that they are following Right of Fair Compensation Act because they are following the spirit of that while determining the amounts of compensation. So may I just place everything before your lordships?
Not necessarily. My only question is you argue only on that. Show me that oil after purchasing is required to pay those two. They follow whatever may be.
My lord, not complete as of now. No agreement to sale.
There's an agreement for sale.
Sale deed has been executed as of now.
Necessary. The doctrine of holding out will apply. There's no way out. You cannot get rid of it unless you seek a declaration before the court that a sale deed is bad, agreement for sale is bad.
I'll address
It's a
your,
case of fraud.
I'll,
It's a registered agreement for sale.
I'll address your lordships with each and every point, my lord.
Now,
Lordship will grant me 1 week time, my lord.
why?
Lordship will take up this writ petition in the next week because it has got some documents and records which will be relevant for the other case also, my lord.
Not
So that's
necessarily.
why-
We are not concerned. I'm only concerned with your petition. Your petition, you cannot improve your petition beyond what is there.
I
Your
am-
relief, what you are asking it cannot be further enlarged in this writ petition.
Lord, whether they are to follow the Act of 1962 or not, my lord, in my respectful submission, it's a purely a question of law. It's a mandate of law that if you are,
After having entered into an agreement for sale, can you say that?
where is the sale?
After entering, I am not saying deed of sale, Mr. Counsel. After entering into the agreement for sale, can you say that?
One thing I'd like to clarify, my lord. So
Yes.
far as my instruction goes, this power of attorney was given to Babul Sonowal for the land, excluding the right of way given to the oil. So far as, my lord, I'll just check up.
No, you don't make submission just for the sake of it.
No. I'm just, we have stated,
Don't behave like Mr. Sharma.
I'm sorry, my lord. My apologies.
Don't
I
make
was-
that
I
submission.
was not prepared today, to be
Well,
very honest, Lordship.
No,
First
I
of all,
was-
both the councils should know that whenever the matter is listed before this court, you never know it may finish up. Yes. So it is never know.
Lord, we have stated
Yes.
373, my lord.
No, let us see that power of attorney.
Page 370.
Page 250 is the power of attorney.
Page
250,
373.
250.
Two 270 is the agreement to sale. Where is the power of attorney?
Doha kaun sa? Tail word is there, page 254, last paragraph. Page 254, last paragraph. To do all, any and all the acts, including sale.
373. Page 373 is our, my lord, stand, my lord.
Wherever you stand, we go as by document.
Page 254, last paragraph, will also.
Except any advance payment, part payment, GRAT payment, or any compensation in respect of the land of so and so, including so and further, also to collect, receive, appropriate, and utilize the same. Any or all of the amount is received in the said amount. Appropriate also is given. To represent us and execute deeds of sale, agreement for sale, deed of sale. And you see, Mr. Das, kindly
Yes.
see.
Our
No, wait. Come to page 252.
252.
Yes.
Agreement to sale.
Whereas late so and so, that is your grandfather, who expired sometime in the year so and so, was the original sole and absolute owner of all lands comprising of total so and so, so and so, so and so. Now you see. Page 255. Now, therefore, we and these present so and so, I, Priyanka, hereby have appointed and authorized so and so, to sell, lease, transfer, and convey all my share and interest of any part or all of these land of so and so. So it includes each and every land, including this 39 bighas. So don't come up with that.
Lord, I go by my stand in page 373. Lord, that is part, my lord.
Your
Only thing-
question, Mr. Das, kindly,
praying-
Mr. Das, I will give you an think over. What you are trying to do is unnecessary. What is the petitioner trying to do? Petitioner is here. Why don't you go before a civil court and seek for an injunction? Go there, file and suit suit to that effect that he has no right to alone appropriate. Attach that property to that effect. Attach that amount and ask them not to make any payment to them. Get an injunction there. Can this court further give you more advice? What are you doing out here has no meaning. This court has no meaning. This exercise cannot be done. Now you know these facts, what has happened. Go there. Challenge this power of attorney. Challenge this agreement for sale. But you have to do it before the civil court. Why you are not understanding? Filing a writ, what you are trying to do is this. That give me less compensation. I don't want so much. You are giving 7 crores is too much. I need 94 lakhs. I'm happy. All 35, we are happy. 38 or 37.
30 and 14 crores, in fact, 7 plus.
It's okay.
14 now.
He is happy with 94. Can that be a justification, Mr. Unless your bona fides is there that you are not going to interfere with them. Think about it. Because what you need to do is to file a suit. Get an injunction against the respond number 5.
One question.
No further amount should be. Yes, he had no right. I also tell you, he had no right to enter into an agreement with him. Yeah. But the fact remains.
No, not about him. The oil also doesn't have any right to enter into an agreement with him.
But have again entered and paid the compensation.
Exactly, Lord.
Now what is to be
What type
done?
of system they are following?
Well, what is to be done now? Tell me. It's a case of recovery. Unless you show that the amount
Lord,
which is
I
there.
have a small question in my mind.
Yes.
The question that I have in my mind is that apart from petroleum, this act, PMPP act, because what they have, what from the transcribed from the records, that the way they have calculated the thing, right of fair compensation act comes.
How?
That is a question I am asking myself.
Don't ask. But tell me, when you submit, make it, don't keep up with the question to yourself. How do you bring the right of fair compensation to the 62 Act? The 62 Act does not involve that. Because here is not a question of acquiring the land, acquiring only the right of way.
Yes, yes. Here we are purchasing the
No,
land.
Here they
now
are purchasing.
that's why all along in the affidavit, they are saying we are acquiring
Uh-huh.
right of way. Now they are saying in tune with your lordships, whatever has fallen from your lordships. No, we are now purchasing.
No.
But they stand in the affidavit.
Mr. Das, you
I'm
also
sorry.
know
I'm sorry.
whatever they write in the affidavit is
But they have
nothing is going
mixed
to
up
happen.
everything.
Nothing would change the classification or nomenclature of the document. With the document categorically say it's an agreement for sale or purchase of these 39 bigas.
So are you not required to pay right of fair compensation under the?
Why? It's a sale deed. Mr. Counsel, try to understand. It is when it's a direct sale, there is no requirement of payment of right to fair compensation. Tomorrow, if somebody comes out and wants to purchase a plot of land from you, are you going to say that because it is the state that the government of Assam wants to purchase the land from you? You said no, you have paid me the right to fair compensation. And if it is the right to fair compensation, I tell you, it will be much less.
That is for 3.5. That is for 3.5. But the prior 7 and 94, my lord, that is
my
still
question.
gray area.
That is my question.
That is still a gray area.
Here, if you want to inquire, have an inquiry as to
Milord, for
why the 7. That is why I put the question to Mr. Sharma. How 7 and 94 has been paid when you are purchasing the land?
Nothing. No, they are not purchasing. At that point of time, what they are saying is that we are acquiring the right of way. This purchasing business has come later. What you will kindly appreciate. That's why, Milord,
This purchasing business came 2 years later, 24, and you have approached in 25.
That's a different thing altogether. I am on the intention of the, because they are shifting their stand. So for the 7 crore and 94 lakhs is concerned, their stand is that we are on the right of way. So we are giving surplus compensation.
So you should be what is your claim? Your claim should be against them.
My submission
Which
is
they say that they have
why
taking into a calculation all we have paid you 36 lakhs. You paid 36 lakhs to them.
that
34, 36
No,
lakhs.
what they are saying, my lord, that is a thing that's already, my lord, clarified before your lordships. My question, again, I'm repeating, my lord, whether so far as 94 and 7.02 is concerned, my lord, whether this right of fair compensation, for that only, I'm not, lordship will kindly separate, for that, my lord, will it not come? My lord, that is, my lord, my
No,
question.
right to fair compensation would not come.
Lordship will give me some time to just apply my mind, my lord.
It's ultimately for the purchase of the same parcel of land.
Huh?
How can there be two procedures?
In fact,
No,
what I feel,
that
Mr.
question
Das,
they should give.
no,
That
please,
We have paid
Mr. Both of you raising your voice in
I'm
this
sorry.
court would make no sense out
I'm
here,
sorry.
or that
I'm
I'm
sorry.
going to change my opinion.
No, no,
today.
I'm sorry, my lord. My lord,
My
as
therefore
on that,
question is, both of you, whatever may be, you may very well put your voice outside, whatever may be, but not in the mic out.
I'll keep it.
Yeah. So therefore, my question, my only thing is, why the oil is paying so much?
That's what.
There's no justification.
Justify.
Why should I now?
We are not here in a public inquiry.
My understanding is that I may get more.
More?
If you want to get more, you take that amount and take the other amount and finish it off. Instead of going for this fight unnecessarily. If the state if the state is paying more money, which is not actually necessary, if they are paying him, you have a claim against him.
My lord, I think the state was required to pay whatever they have paid for surplus compensation and rehabilitation. My lord, I think, my lord, the pattadar, they are entitled to more. Lordship will allow me to
How?
explain. Lordship will, because
How? Well, because they're not acquiring, they're purchasing it.
this two amount is concerned, my lord.
You do one thing, you get the money from them, the 7 crores.
In fact, this will be a pointed query to my client today. Why did you pay this money?
Why is it necessary for you to pay this 94 lakhs
And
and
this
so and so?
7 crores.
The moment you take
When
that
there was
money
an-
out there, you are free.
When there is
He's
an
out.
agreement of sale being registered for 7 crores, why did you pay another 8 crores extra? This is one query I'll put
There
to
was
my
no
client this time.
necessity.
Exactly.
In fact, it is a loss of the public exchange.
Yes.
After oil is also a public government area. This is our money. This is the government's money. So obviously, this is you should take it, recover it as Bakizai proceedings from them.
In fact, that's true.
Better off.
Why?
Because there's no justification of paying this. Because when you have entered an agreement for sale, I've never heard of this. This is the most unusual thing which has happened.
Agreement for sale has the latest
Ask Ms.
development.
Let us ask.
That doesn't better his case. However.
Let me ask Mr. NC Das. He has done a lot of matters on this petroleum, isn't it, Mr. Das? Because you have been doing for these transmission things and all these things and petroleum out there. What is payable? It is very less amount. The surface compensation is so meager an amount. The question of Assam land and Assam, the right to fair compensation does not come into the scene at all. They pay only to the value of the land, 1/10 of the value of the land which is being paid. There's no question of solicium also, because of the fact that the use of the land is always there. But here is a case they are purchasing, and once there is a sale which is being purchased, where is the question of surface compensation or rehabilitation? Because the rehabilitation does not come. Rehabilitation comes under the Right to Fair Compensation Act. That is comes under the Schedule 2 and Schedule 3. This is not there. Never heard of. Chalo, you just get on what basis you have paid.
I'll get that.
And then we dismiss his petition.
Friday, Lord.
On the Friday, I'll be out of any date in the.
I don't grant.
This Friday?
I can grant him the accommodation, not to senior counsel. Senior counsel, I don't grant.
Not tomorrow at least. Next Friday, fine.
Not Friday. Pursuant to the order passed by this court on 31/7/2025, the petitioner herein had deposited the amount of rupees, the amount of rupees 34,16,688 along with interest at the rate of 9% per annum, totaling to rupees 44,48,689. And this aspect is apparent from the office note dated 3/8/2026. Post. In the present proceedings, it is seen that the petitioner is one of the shareholder, co-owners and you have not made the other co-owners a party?
No, I'm representing.
They did.
I'm representing them. Whom? 36.
Yes, ma'am. It's there.
Remaining 36.
You're
Yes,
representing party.
Yes, my lord. They have
I
filed
filed an
affidavit also
application
against
for
which, my lord, I
implementation.
wanted to file it.
And what is your stand? You have filed your affidavit.
Lordship, we have filed.
You are appearing for whom? When did you become a party here?
But I have filed an IML for
Pleading.
pleadment that was allowed. And
Huh?
I pleaded as a respondent number 7 to 42.
And what is your stand?
Everything is that this is all afterthought, my lord. He wants some more money, she wants some more money. Initially, Bikram Soma wanted. So, my lord, Bikram Soma demanded, my lord, the intending purchaser.
You mean to say that we can appropriate this 44 lakhs, giving clean sheet to respond number 5 and
For now, for 4.
4, and the High Court, then we can appropriate that amount of 44 lakhs and place it to the flood relief to the petitioner.
Those amount was in fact paid towards, my lord, the compensation as well as the land valuation. Land value.
Why is he paying that amount? He has not got the amount for the land compensation, for the land sale of the land.
My lord, for this, my lord, that agreement has been entered. But the Babul Sunwal, my lord, the
He's not Babul Sonwal.
Babul Sunwal representing the remaining 36. Initially, our entire 38 had given me the, my lord, power of attorney. Subsequently, the writ petitioner and one Bikram Sharma, they have, my lord, released the, my lord, revoked, my lord. So far as his pleading is concerned in the writ petition, it is nothing that he has revoked.
How the revocation has happened?
But this day said, my lord, revocation. my
You are
lord,
party to the revocation.
document, my lord, I don't have.
Anyways, I think you, all of you should
The
prepare your
attorney
matter
has
properly.
appointed the Oil India Limited to pay the amount to, my lord, this NB Sunil. Chopra
Understood, but
company.
the question is, you should be knowing you are appearing and anyways, কি লিখে এইটো? সেইটো সেই amount খিনি দিয়া হ'ল। বস্তু। From the materials on record, it is seen that the respondent number 2, for the purpose of laying the oil pipeline, had entered into an agreement for sale on 10/4/2024 for purchase of 39 bighas 4 katha 11 lechas of land. Agreement for sale, that the total consideration of the said agreement for sale is rupees 7 crores 1,22,000, out of which an amount of rupees 3.5 crores have already been paid to the attorney holder of the petitioners, along with the private respondents. Private respondent numbers 5 to 46.
42. 42.
5 to 42.
3 crore 50 lakh 61,000, my lord. 3 crore 50
7
lakhs.
to 42.
3.5 crores is okay.
Well, I am repeating 7 to 40.
addition to that, on account of rehabilitation, an amount of rupees 7 crores 2 lakhs 84,000 have been paid to the respondent number 4. And a further amount of 94 lakhs have been paid to the respondent number 4 on the account of surface compensation. Mr. H.K. Das, the learned senior counsel, submits that the petitioner is in the present proceedings is not on the aspect pertaining to the agreement for sale. Case of the petitioner herein is as to why the respondent number 2 had paid to the respondent number 4 the compensation in terms with the compensation on account of rehabilitation and surface compensation. This court have put a query upon Mr. A. Sharma, the learned counsel appearing on behalf of the respondent number 1 and 2, as to what necessitated the payment of the rehabilitation as well as surface compensation when the said land is being purchased by the respondent number 2, as would be apparent from the agreement for sale. Mr. A. Sharma, the learned counsel, appearing for the respondent number 1 and 2, submits that he would obtain instruction and place the same on the next date. Mr. P.J. Soikia, the learned counsel, senior counsel who represents the respondent number 7 to 42, submitted that the present proceedings is an abuse of the process of the court, inasmuch as the petitioner have invoked the public law remedy in order to get further amount from the respondent number 4. The maintainability of the writ petition shall be taken up for consideration on the next date. More particularly, when the informations which have been sought for in relief in the relief number 1 and 2 is already available in the affidavit filed by the respondent number 1 and 2. The question arises in the present proceedings as to whether this court, in exercise of powers under Article 2 to 6 of the Constitution, can grant the reliefs number 3 and 4 when already exists an agreement for sale wherein the petitioner is a party and the compensation and the surface compensation as well as the rehabilitation compensation have been paid to the private respondent number 4, and the dispute prima facie appears to be a dispute between the petitioner and the private respondent number 4. Well, is this matter on? I'll give you an unlucky date, 13th. 13th of August 2026. You cannot go, that's a Thursday.
Not going, I'm just thinking because 13 other matters are there, High Court matters. So it may be, can it be 14 or?
14 days, because of you, so
Friday.
much time has gone today.
My lord, one small prayer, my lord. They are repeatedly saying in their affidavit that they entered into a bilateral settlement. That settlement is not before this honorable court, my lord. So
Maybe
like to
that
see
will come as the instruction. That will come as the instruction.
Let them come,
Look at
let
And
them come.
one MOU they are referring to, none of the parties has produced that MOU.
Understood, everything is understood, but question remains again that you and him, he has unnecessarily taken the money from you. Now, whether you will be happy with that 44 lakhs back or should
Lord,
it go to the
Although
That
say
is-
right of way,
that
oil,
relief?
my lord, oil is determining compensation in terms of the 2013 Act. Otherwise, the amount could not have come so much.
This matter again on 18th of August 2026.
18th.
2 p.m.
Highly obliged.
Obliged.
Much obliged.
That hearing was done, Lordship, he was asked to appear, he did not appear, and it was informed to the DC as well. But Lordship, I have not received the written instruction. So can it
My
be on,
question is,
he was given the opportunity.
Hmm?
He was given an opportunity, Lordship.
where is your notice to him?
Lordship, I have received the telephonic instruction. Can it be on, Lordship, Friday at 2 p.m.?
You were present on the last occasion.
Yes, Lordship, I have.
Then,
Lordship,
don't you know that the matter would be taken up for final disposal?
Lordship, the written instruction, they were supposed to furnish me the something in writing, but could not, Lordship. So
My lord, the letter at page 32, this is the letter we have first received.
Huh?
The letter at page 32, this is the only communication which we first received. That informs us that birth certificate is cancelled with immediate effect. Before that, no information has been given to us.
They participate in the inquiry. This submission is totally wrong, my lord. I can show from my whatever documents I have, I can show from that also. Besides government affidavit, means government affidavit would be.
From your document that there was a notice issued to the petitioner?
The inquiry was there. Total inquiry was there. He submitted all these documents, page 60. My lord, your lordship, can first, sir, first see, my lord, section 50.
I'm not going to go into the section. First, show me the notice was there.
62, page 61. And the government will show the records, my lord. More. Your lordship, this is a communication to the branch manager pursuant to the inquiry conducted, and he was there with reference to the subject cited above, the undersigned for inquiry.
My question is, where is the notice to him?
That your lordship will take it from there.
They have not filed it, so we set aside that.
My lord, that will be wrong, my lord. If your
Not wrong.
lordship passes, then your lordship will hear me.
I'm hearing you.
Yes, page 61, your lordship will kindly see.
Yes.
So I have a small submission before my.
No, it's okay.
First, before your lordship, I take your lordship to the thing, my lordship will kindly look into section 15 of the act. Yeah.
Yes.
Yes, section 15, your lordship. Then page 61.
Page?
61, then after that, your lordship can take page 61.
Then what
Then
does
page
section
61.
15 say?
Then,
What does section 15 say?
my lord, if there is doubt, correction or
If it is
cancellation of
not doubt,
entry
if it is
in
proved.
the register of births and deaths.
No, no, Mr. Counsel,
Yes.
it is, if it is proved,
Yes. My lord, then thereafter.
can
what
there
is-
be a proved ex parte?
Not the ex parte, my lord, he was, I'll show, that's what I'm showing.
Show
Page
me the
61.
document which shows that a notice was given to the petitioner.
My lord, your lordship will kindly see page 61.
Page 61.
61.
Okay, then
This is a letter addressed to the branch manager by the registrar of birth. It says, matter with reference to the subject cited above, mentioned above, the undersigned for inquiry the birth certificate of Abdul Karim registration number so and so and his date of birth is so and so respectively, which was issued from the office of the. In this regard, Abdul Karim produces his relevant documents. How he produces the relevant document? After getting information from the register of birth, because we filed a complaint, that complaint is at page 56. Complaint is at page 56. Page 56 complaint, then this letter was issued. His relevant documents and Xerox copy of bank passbook of your respective branch to meet the inquiry. Here Abdul Karim's customer ID number is so and so and his bank account number not clear in the bank passbook. It is mentioned here that during my verification, I have seen in his birth reporting forms, his mother's names firstly written as Moni Bibi and later on Moni Bibi struck out and written as Turan Bibi. And in bank passport book, his nominee name is Moni Bibi. So I am in doubt who is Moni Bibi and what is the relations with the nominee. In this connection, for verifications of birth certificate of Abdul Karim, the undersigned required the following the informations of Abdul Karim in support with the bank account. Then the bank gives the information, page 62. With reference to your letter number so and so, we would like to inform you that as per our bank record, Mrs. Moni Devi, not Suren Bibi. Suren Bibi is my mother's name. Moni Bibi is registered as nominee of account holder Abdul Karim, petitioner, and Mrs. Moni Bibi is the mother of the account holder as per our record. This is for information. Then the letter and the bank's paper has been shown at page 63. Then your lordship will kindly come to see page 65. This is the birth certificate they have given. Huh? Yeah. Page 64. In response to the subject mentioned above, the undersigned for inquiry, the birth certificate of Piara Begum, white registration number so and so, which has issued from the office of the. In this connection, Piara Begum produces her relevant document. This produce how they produce. Only after inquiry, after getting information from the registrar and school certificate to meet the inquiry as per Xerox copy of the so and so, dated so and so, which has issued by headmaster of so and so school. The date of birth of Piara Begum is 15/6/1988, and as per said school certificate, she left the school on 2001 and no countersign thereof in the school certificate. In this respect, comparing with the birth certificate and school certificate as mentioned above, the date of birth of Piara Begum in birth certificate is 91 and in school certificate is 15/6/88. So the undersigned required information regarding the authenticity of the school certificate which has issued by the headmaster of so and so school as details above. Then your lordship will get it at page 65. 67, my lord. Cited above, I would like to inform that there is no school by the name Bolahari High School, post office so and so, as per records available in the office of the undersigned. As such, the question of giving counter signature by the inspector of school, KTC Karimganj, in the school certificate of the above mentioned school does not arise. So he was, my lord, pursuant to that complaint, my lord, he was asked to submit certificate and all the documents which he has submitted, and the same was inquired into by the officials. Then thereafter they came into conclusions. It's a fraud committed by them. What's the protest? All the certificates which he has annexed after he claimed that his date of birth is 91 and 96, and he obtained a certificate in the year 2013. on the basis of documents, my lord, apparently, my lord, false documents submitted by him.
Not going to look into those.
Yes.
I'm only saying as to where there's nothing mentioned to the effect.
Yeah, that inquiry, my lord, he has,
No,
he has
that
submitted.
inquiry is a unilateral inquiry.
Then your lordship will kindly wait for the affidavit from the government.
I won't wait. We impose a cost of 10,000 upon the bank, upon the health department.
I cannot submit more than this one.
So the respondent.
And if your lordship sends it back, my lord, let them decide it within a period of 1 month. And this certificate shall not be acted upon for any purpose till the final decision.
That cannot be done.
I leave it to your lordship and then I'll have to take.
Apart from
I may direct within 1 month, let them decide. Is their lookout, they can very well pass an order to the effect that not to they take into account that certificate for the time being. They may suspend that certificate. They have the power to do that.
Your lordship may kindly record that.
Why should I record it?
Because on the face of it, my lord, he's not producing any document in proof
Mr.
of
Das,
nothing.
we are not concerned. Tomorrow, whatever may be, first of all, without informing them, you could not have.
After informing them, then only they have submitted the document
by which a
That
notice
page
has been
61
issued to
itself
them.
shows. So that your
Why
lordship.
should I read into the mention to the
No, no,
debate and
this
during the inquiry these
this
documents are
certificate
submitted?
has been cancelled and issued by the authorities represented by my learned friend. He is seeking time from your lordship. 1 week time, my lord, ends of justice, your lordship will, that will be.
Okay, we give him 6 weeks time. We stay that or impugn order. We stay this impugn order.
Well, that will be against my lord.
That it will be more harmful to them. It's okay. we stay
Harmful
this
to
order.
me, my lord.
Whatever may be, we stay till he is asking if you are supporting.
Lordship, I've received some
getting
instructions.
a support from him.
Lordship, I've just received some instructions, some documents, Lordship. May I just?
Yes.
It's P1 itself shows that the authorities look for their document. They are taking my mother's name and father's name.
So my lord, the respondent number 5's main contention is that they are questioning the paternity of the petitioners, parentage, in fact. So under section 15 and rule 11 of the rules made under the act, the register doesn't have power to determine a question of parentage. This is something that a civil court should decide. And a civil suit was in fact filed by one Amadul Haq who proposed to buy some land from the respondent number 5. And that civil suit has been dismissed for default. So this issue remained that way. However, they have, after that, they have filed this complaint questioning the parentage. And under section 15 and rule 11, the register doesn't have power to determine parent. That aspect may kindly be considered also. If they can go for determination of parentage, if they have any problem.
Section 13(3) also. Initial certificate itself is wrong matter. After so many years, certificate was issued without any magisterial inquiry. Now, yesterday, Parliament has passed a law that it has to be inquired into by the judicial magistrate. Yesterday, I think. This is what I read. After 2 years, any certificate is given, judicial magistrate has to inquire into. This is the present law.
Who are you?
I'm respondent number 5.
What is the
My
name?
father's name has been taken. My name is Leela Begum, my lord. My
Leela
father's
Begum is who? Is the wife of
wife of Royce.
Roy Ali.
Leela Begum is the
The
daughter
Daughter of Royce.
daughter of Royce. Royce.
Leela Begum
Suran
is
Bibi is
daughter
the
of-
wife
yeah.
of.
What is your mother's name?
My mother's name is Suran Bibi.
So he has brought his father's name as Roy Ali.
Yes, that is my father's name. My father's and my husband.
The husband is how?
My father, man.
Your father has been put in the birth certificate.
Yes. And after
Your
so many
grievance is only in respect to that aspect.
Yes.
So if that is your grievance, not on the basis of his date of birth,
No, my.
no, not on the basis of his date of birth, can you agitate that issue before the Joint Commissioner or these authorities?
Because my father's and my mother,
Whatever may be, it is not on the question of date of birth. It is on the question of whether who is the father.
because in that certificate.
No, so therefore, how can you raise that issue before them?
Register up because.
Register has no business out there. How do you have the jurisdiction?
And to cancel the birth certificate.
Not
given,
you.
my lord, yes.
You take your seat. How do you have the jurisdiction to decide who is the mother and father?
No, Lordship, since there.
You see, the grievance on which the petition was, the entire proceedings was initiated, was at the state, at the instance of the respondent number 5. The respondent number 5 does not question the date of birth of the petitioner. He doesn't know. She doesn't. What she questions is, you have put the wrong father and mother. Now, can you decide who is the father and mother? My question is this.
For which, Lordship, so far as my instruction is that they were asked to come up with some documents.
I'm not on that. Do you have the jurisdiction to decide who is the father and mother? So then the entire proceedings which have been initiated is wrong. Forget about natural justice. Bibi? Moni Bibi, one is Roy Ali and one is Rojaz Ali.
Royce Ali, this, the different spellings.
Huh?
Royce Ali.
Then there are two persons. Kindly come to page 29 of your petition. Puran Bibi is married to Royce Ali.
Royce Ali.
R-O-I-S. Whereas Muni Bibi
Yes,
is married to Royaz Ali.
Riaz Ali.
Not Riaz Ali, Royaz Ali. R-O-I-Y-Z.
In vernacular, it is written Riaz Ali.
So Royaz Ali.
Yes. So he is different.
So as per the respondent number 5, you are the son or daughters of Moni Bibi and Royaz Ali.
Yes, maybe they are claiming.
That's their stand.
They are denying that we are the son and daughter of Rohis Ali and Suran Bibi.
Now, in your case, Pyari Begum, father name is given Royaz Ali. And this is the NRC draft.
Yes.
RC cancellation, cancel.
voter ID card at page 26, my lord. 26 and 27.
Who is Abdul Karim? You.
Yes.
You filed a suit.
No, there is a suit. We have filed a suit challenging the cancellation of birth certificates. After the birth certificate got cancelled, we filed a suit seeking a decree of declaration that the cancellation is void.
And what was your alternative remedy for which the writ petition your suit was dismissed?
Simply, it is stated that suit is barred under section 28(1).
Because there is an alternative remedy.
Alternative remedy is mentioned in section 28.
Well,
but
what is 28(1)?
28. There is
No suit of AR so and so or any other legal shall lie against the government, the Registrar General, or exercising any power or power performing under this act for anything which is done. It tended to no suit or legal shall lie against the government for any damage caused or likely to be caused by them, anything which is been done in the act, not in the.
However, there is a provision for appeal, my lord, which
Where?
was inserted in 2023 at section 25A. Section 25A of the act.
Where is that?
It is
not here.
inserted by amendment of 2023.
Registration of births and deaths contributed. Registration of births and. Show me to read that. Hang on.
The certificates were cancelled in 28/1/2022, and the provision for appeal was inserted with effect from 1/10/2023. So therefore, we filed a suit. There was no provision for appeal at the time.
Rule 11(6), your lordship will kindly repeat. Assam rules.
What is your instruction?
If this is one inquiry report, Lordship, which is furnished to the district commissioner, Lordship.
So here also you have not issued notice to him.
The notice is not there, Lordship, but notice they have not furnished me, but is an inquiry, Lordship.
Where is that document? Hmm?
But the register has furnished the inquiry report to the DC, Lordship. The last paragraph of that, Lordship, report. In para 13 of that report,
Put the mic.
para 13 of that report, Your Lordship. Besides all the aforesaid facts, I have taken statements of some local people, Moinul Haq, son of late so-and-so, son of so-and-so. All are the residents of ward number 3 of Karimganj town who have stated that they know both Priya Begum and Abdul Karim, who are not the daughter and son of Rois Ali. Statement of the aforesaid 3 persons.
Understood. That is okay. My question therefore is, can you ascertain, do you have the jurisdiction to ascertain the date, the mother and father? One. Secondly, nothing mentioned in the report that you have inquired with, have you informed the petitioner. Did you submit this inquiry report to him? No. These are all unilateral things done.
Yes. But
We have
Lordship,
only
if
these
there
two
is,
grounds.
Apart from natural justice, the most fundamental question is, can you decide? Do you have the authority to decide
who is,
as to whether the father or mother?
no, Lordship, that we don't have,
And,
but
and apart from that, I don't understand another thing. How a certificate of birth, which only is to denote the date of birth,
yes,
can be used for the purpose of deciding who is the father and mother.
yes.
The certificate of birth cannot be the basis. I would have understood the register coming out there. If he had very well taken that ground which is there, kindly come to page 60. You have a copy or don't have the file?
Yes, Lordship, I have a copy.
Page 60. The Joint Director of Health Service had categorically mentioned, why didn't you bring it within the scope of this? The third paragraph from below. Your case is simple. You should have brought it within this ambit. Why you are going into the question of other aspects? Ask him only to that effect that without the magistrate, this cannot be done. Matter would have been finished. Now, what you have done is you have entered into a territory which is reserved for the Election Commission, which is reserved for the NRC, which is reserved for the Civil Court. On the issue, how can the Register of Births and Death decide who is the mother and father? You have the power.
If there is any doubt regarding the birth certificate, then we can cancel it or modify it.
Understood. But can you decide on the question who is the mother and father?
No, Lordship, that we cannot.
So if you cannot decide it, you should have gone into this aspect. It is clearly given, and the Joint Director of Health have categorically asked you to look into in this aspect and put a notice to him and finish it off.
Yes, Lordship.
Without going into the mother and father business.
Yes.
And that purpose of respondent number 5 is served without going into all these things.
Yes.
That is the only way out.
Lordship, that can be done.
The different thing that would not serve the purpose of the petitioner and all this. Don't go into the mother and father. Go into the question as to how this certificate could have been issued without this thing. That's all.
Yes, Lordship.
Yes, ma'am. May I place a judgment on the authority of the registrar to cancel?
And the birth certificate is issued by whom?
The
The
register,
municipal
birth and
register.
date,
Municipal
register, birth and date.
He is the competent authority. Paragraph 9, my lord, reproduces this section 15 and rule 11. The Kerala rule and Assam rule is same, my lord, perimeter area. And paragraph 12 is the conclusion. It holds same as your lordship has observed.
Do we have any government circular on this aspect?
I'm not aware, my lord, but rule is same, my rule is same. The rule 11 of Assam registration of births and deaths rules 1999 is perimeter area to the Kerala rule.
May I just point out one thing? Lordship will kindly see that section 15, section 13.3, your lordship has seen that if it is beyond 1 year, then ministerial inquiry. On that line, they could have finished it. That I understand, my lord. But for the purpose of clarification of that section 15, correction, your lordship will kindly see that form is there, form 5. I have given a copy, my lord. Form 5, what is to be enclosed for the purpose of providing the certificate. It says, my lord, name of the father, name of the mother, and all those details are required. That form is there. So that is any entry in the form is wrong, then they can go for correction cancellation. Name is there. Name, father.
No. The
father's name.
moment there is a dispute being put before them,
Yes,
that whether it is the father and mother,
yes.
can they inquire into?
My lord, if it is wrongly put, my lord, then on the basis of the inquiry, they can look into it and they can cancel, because entry means any entry in the form. My father's name is BC Das. If I write his father's name, for the purpose, with some purpose, he can always file a complaint that this entry. in his
Therefore, it is always said that a certificate of birth cannot be used to decide who is the paternity.
Well, if a wrong.
Now somebody is using that particular document and some courts or authorities are accepting it, that's a different thing. But a certificate of birth is only for the purpose of ascertaining the date.
No.
Yes.
Father's name, mother's name is also there.
Understood. There
My
might be
date of-
many other things. They may
I-
say also where they are residing.
My father's name and mother's name is also, because that is also an entry in the
Cannot be
certificate.
done to that effect.
I'll just point out, man, why I'm saying, section 15, your lordship will kindly see.
That power cannot be granted to these authorities.
If it is besides 13.3, your lordship can send it back. Okay, that registration is not there, where that inquiry is not there by the magistrate. On that itself it goes. I understand that. But at the same time, regarding the father's name, mother's name, my complaint is to that extent. If it is proved to the satisfaction of the register, section 15, that any entry of birth or death in any register kept by him, any entry means if my father's name, mother's name, residential address, if anything is wrong, if I file a complaint, he can look into it and he can cancel it or he can correct it.
That means you are giving him the authority of a civil court.
No.
Yes.
Civil court is barred.
He doesn't have the authority to
I'm
that.
just submitting, your lordship will take into consideration, section 15 says any entry in the date of birth.
Civil court is barred when there is an order being passed.
But this
But
power
as
is given to
regards as regards the question of deciding the authenticity as to whether it is father or mother, that's he has no jurisdiction to do
They have looked into it and the bank says this and the inspector of school says that.
These are all ex parte, Mr. Counsel. These are all
He
ex
was heard,
parte.
the document which is enclosed with my affidavit itself shows that the inquiry was there. He was asked to produce certificate and all. If your lordship thinks that he was not heard, my lord, on that first plea itself, first ground itself, that the
No,
certificate
I
is
will also say that he has no business out there. Decide on the father and mother.
Yes, your lordship may put it, but your
He
lordship
can
may
very
kindly-
well look into it. As regards the AR of 13.3, that without a certificate, without the magistrate AR, if it is done, then it would be, that cannot be done as per the certificate cannot be done. There has to be a magistrate's AR. That
Yes,
needs
that
to be
is there.
looked
On
into.
that ground itself it goes.
In fact, that is being given by the joint director of health service.
At page 60.
That has not been considered by the register of
that
births and death, has unnecessarily gone into. That is register and births and death have been more particularly swayed by the complaint.
On that ground, your
Since there is a
lordship
line,
demands that
kindly
matter.
inquire, so he went to the inquiry.
Will not have it. Level.
On that ground, my lord,
Mr.
within a month. my lord.
Scott, learned counsel appearing on behalf of the petitioners. Mr. E. Upomenu appears on behalf of the respondent numbers 1 to 4. Mr. B. D. Das, the learned senior counsel, assisted by so-and-so, appears for the respondent number 5. The petitioner number 1 and both the petitioners herein are aggrieved by the communications dated 28/1/2022. There are one communication or two?
3 communications.
28/1/2022.
Page 32, 33, 34.
As well as the subsequent communications dated 24/6/2022, which have been enclosed as annexes 6, 7, and 8 to the writ petition. whereby the birth certificates of both the petitioners have been cancelled by the respondent number four. Next. The case of the petitioners herein are that they are the case of the petitioners herein are that the petitioner number one is the son and the petitioner number two is the daughter of one late Royes Ali, R-O-I-S, Ali, and late Suran Bibi of Longai Road, bracket, Soralkha Lane, Karimganj. The petitioner was, number one was born on 5/10/1996, and the petitioner number two on 12/5/1991. Isn't it?
Yes, yes.
Good stuff. In the year 2013, both the petitioners in the year 2013 and more particularly on 15/11/2013, both the petitioners obtained their birth certificates issued by the respondent number four. A perusal of both the birth certificates revealed a perusal of the said birth certificates revealed that insofar as the petitioner number one is concerned, the date of issue of the said birth certificate is 9/6/2015. And the registration date is 15/11/2013. However, in the case of the petitioner number two, only the date of registration of the said birth certificate is mentioned as 15/11/2013, and there is no date insofar as the date of issue. In the case of the petitioners that the petitioners were served, the petition is the case of the petitioner that the petitioner were furnished, petitioner number one was issued a communication by the registered respondent number four on 28/1/2022, informing him about the cancellation of his birth certificate and further directing the petitioner to return the said birth certificate. Subsequent thereto, by two separate communications dated, both dated 24/6/2022, both the petitioners were informed about the cancellation of the birth certificate . and directed the petitioners to submit the cancelled birth certificate before the respondent number 4 on or before 28/6/2022. The petitioners who filed, only one person or both?
Both, right? Both.
The petitioners being aggrieved filed a suit being title suit number 214/2022, assailing the cancellation of their birth certificates, which have been enclosed as Annexure 6, 7, and 8 to the writ petition. Suit, which was filed before the Court of the Civil Judge Junior Division number 3, Sri Bhumi, was registered and numbered as title suit number 214/2022. The said suit was dismissed on the ground that it was not maintainable in view of Section 28(1) of the Registration of Births and Deaths Act 1969. It is under such circumstances the petitioners have approached this court by filing the present writ petition. Duly takes note of that initially the respondent numbers 1 to 4 were only parties. Subsequently, on an application being filed by the respondent number 5 in IAC number 171/2026, the respondent number 5 was arrayed as the party to the present proceedings. The records reveal that notice was issued on 27/8/2025. Even after a passage of almost 1 year, the respondent numbers 1 to 4 have not cared to file their counter. On the other hand, it is relevant to take note of the affidavit which have been filed by the respondent number 5. A perusal of the said affidavit reveals that it is on the basis of the complaint filed by the respondent number 5 that the proceedings were initiated for cancellation of the petitioner's birth certificates. This aspect would be apparent from the communication dated from a communication issued from an undated communication issued by the respondent number 5 to the respondent number 3. A perusal of the said communication, which has been enclosed as Annexure 1, would show that there is no contest, that the respondent number 5 do not contest the date of birth of the petitioners. However, it is the case of the respondent number 5 in the said communication that the names which have been inserted, that the father and the mother's name which have been inserted in the birth certificates of the petitioners are incorrect, inasmuch as late Royas Ali and what's your mother's name?
Suran Devi.
So and so. Where the parents of the respondent number 5 and the parents of the respondent number and the father and mother of the petitioners were Whom? You have not mentioned. First. Basis of the said communication. An inquiry proceedings was initiated by the respondent number 3 by issuing a communication to the respondent number respondent number 4 to the Deputy Commissioner come District Register of Births and Deaths, Karimganj. First. It is also seen that there were certain inquiries being conducted by the responding authorities as regards the parentage of the petitioners. And thereupon, the impugned communications which have been enclosed as Annexes 6, 7, and 8 were issued. The petition was listed before this court on 3/8/2026, on which date this court fixed the matter today for final disposal. When the matter was taken up, Mr. D. Upamanyu, the learned standing counsel of the respondent number, the learned counsel who represents the respondent numbers 1 to 4, submitted that he did not, that the said respondents have not filed their affidavit in opposition. But it was mentioned that the date of birth, that the birth certificates were cancelled. After an inquiry was carried out by the respondent number 4. A set of documents was placed before this court, which included the inquiry report of the respondent number 4. And they have been they are collectively marked. How are these Annexure E, A, C? What are these documents? The letter X. In the backdrop of the above, let this court now consider the respective submissions on behalf of the parties. Mr. Oloskar, the learned counsel appearing on behalf of the petitioners, submitted that the impugned order of cancellation of the birth, impugned orders of cancellation of the birth certificates of the petitioners are in violation to the principles of natural justice, inasmuch as without giving the petitioner an opportunity, the said birth certificates could not have been cancelled. The learned counsel for the petitioner further submitted from the stand so taken by the respondent number 5, it appears birth certificates have not been challenged on the question on the aspect pertaining to the date of birth of the petitioners. Birth certificates have been questioned by the respondent number 5 on the question of the parentage of the petitioners. Counsel for the petitioner further submitted that the question of parentage of the parentage, if disputed, the respondent numbers 1 to 4 had no jurisdiction or authority. As much as the said aspect can only be decided by the civil court. Mr. D. Upamanyu, the learned counsel appearing on behalf of the respondent numbers 1 to 4, had relied upon the documents which have been placed before this court and kept on record and marked with the letter X. He submitted that there was an inquiry being conducted, but on the issue as to whether the petitioner's parents were late Royce Ali and the other one is something, BB. And it was found upon the inquiry being carried out that the petitioner's parents were late. But them, who is the parents?
Mother's name has been found to be Moni. Moni Bibi. Mother's
Parents
name
are
has been-
who?
Mother's name has been found to be Moni Bibi. Page 63.
Other is
Moni Bibi.
other father.
Father's has not been found out here, my lord. But mother's name has been found out to be Moni Bibi, page 62 and
Okay,
63.
yeah, it's not so and so. Nothing.
And date has been,
The counsel further referring to the inquiry report submitted that notices were sent to Moni Bibi as well as the petitioners to appear before the respondent number 4 and to give their statements regarding the matter, but they failed to do so. On 27/7/2020, the petitioner number 1 submitted a petition along with some documents and stated that if any complaint made against him by his sister, that is the respondent number 5 herein, or her husband, the same shall be rejected as the matter is under adjudication in the competent court of law. On the basis thereof, the learned counsel appearing on behalf of the respondent numbers 1 to 5 submitted that the petitioners were duly aware of the said inquiry, and the petitioners were also granted an opportunity Mr. B.D. Das, the learned senior counsel appearing on assisted learned counsel, senior counsel submitted that a fraud has been sought to be committed by the petitioners by inserting the names of the parents of the petition of the respondent number 5. Birth certificates. On the basis thereof, the petitioners are taking advantage of taking advantage. It is under such circumstances, the respondent number 5 had been compelled to submit a complaint before the respondent number 3. The senior counsel submitted that the birth certificate, that the petitioner's date of birth, date of birth were sometime in the year 1996 and 2001.
91 and 96. 91 and 96.
91 and 96. You have put some 2011. What is this? You have put that? Uh, 91 and 96.
5, 10, 96.
And they were issued the birth certificate sometime in the year 2013. 2000
13.
can't be 13, no?
In fact,
Kindly come to page Annexer 1. The year 2015. With the registration date of 15/11/2013. Certificates could not have been issued without the fulfillment of the criteria in terms with Section 13 of the Act of 1969. The learned senior counsel further submitted that the legislature have categorically mentioned as to what steps are required to be taken if there is a delay beyond 1 year from the occurrence of the birth or a death, when there is a request for issuance of a birth certificate. This aspect is very pertinent for the purpose of the present case, in as much as if there is a delay beyond 1 year, there is a requirement of a report of the judicial magistrate.
Still.
Huh?
Magistrate.
What?
Magistrate, my lord, it says. I think-
Judicial magistrate, no?
No, not judicial.
There is a
Judicial
requirement
magistrate.
of
Now the present act has been passed, my lord. Bill,
no, there is a requirement on an order made by the district magistrate or the subdivisional magistrate or by the
Yes.
executive magistrate. Who would verify the correctness of the birth the London Senior Counsel submitted that without the order of the district magistrate or the subdivisional magistrate or the executive magistrate, the petitioners were issued these birth certificates. And a fraud was committed, not only by the petitioner, but also by the officials. And a fraud was committed by the petitioners in concert, in collusion with the officials of the respondent number 4. He therefore submitted that the issuance of the birth certificate, the cancellation of the birth certificates by the impugned orders which have been enclosed as Annexes 6, 7, and 8 need not be interfered with. analysis and determination. I've heard the learned counsels appearing on behalf of the parties and have perused the materials on record. From a perusal of the materials on record, it is relevant to take note of that the petitioners were born in the year 1991 and 1996. Their dates of birth were registered only on 15 11/2013. And the birth certificates were issued year 2015. It is relevant to observe that the birth certificate is issued and is only to be taken into account for the purpose of as a proof of the date of birth and the contents thereof and the other contents starts the place of birth, the name of the parents, permanent address, they have no evidentiary value if contested. It is the further opinion of this court that when there is a contest or there is a challenge to the contents of the birth certificate, so far as the name of the parents, or the permanent address, the authorities, the register of births and death has no authority to decide the same. However, insofar if there is a challenge to the date of birth as well as the place of birth, as these certificates would be issued basis of a verification on the basis of you don't issue the certificate just for the sake of it. You issue on the basis of how? On the basis of either inquiry,
Lordship, there is a form which needs to be filled, Lordship.
you don't
Form five
just,
I have given.
huh?
Form
I've
5.
given Form 5. Form 5 is there, madam. That's what any entry means includes everything, all materials in the form.
Form 5 is there.
Form 1, sir. Rule 5, Form 1. The flag mark is there.
Birth reporting form.
Where?
Reporting form.
There is a flag mark.
Form 5 is where?
Form 1.
Form 1, Rule 5. Wait a minute.
Now you require some document for that.
Yes. Madam, may I just point out this? Okay. Here, Rule 5. Here. Has your lordship got it? It will be there in the room. All this Foreigners Act, which is going on, it is based on these false documents. If any document is found to be false, somebody files a complaint, it is looked into it and is corrected, and these foreigners cases are going on this basis itself. They look into the father's name, mother's name, any entry, my lord, in the certificate of birth is wrong, putting father's name, mother's name, address, then one can file a complaint. On the basis of that complaint, this is how the petitioners, this certificate was also cancelled. NRC. It is, yes, it is annexed here with my lord in the petition I have given. That is how his certificate was also cancelled. NRC certificate was cancelled. The foreigners case are going on the basis of that only. Bringing some.
No, understood. But how do you put the date? The
Date?
father's name, mother's name, if you put it.
Yeah, then date also they verify it, my lord. If they put it wrongly,
Now, how do they put it?
my lord, on the basis of the certificate from the
There
hospital.
has to be something to that effect.
Certificate from the hospital.
Hospital, they issue a certificate, Lordship.
That I know. So
That-
that hospital certificate is there. That is one.
They write the
But
date.
there are 3 types of births which may
Yes.
happen. As you can
Institutional-
see,
institutional
birth can happen in a hospital, institution,
or
Then they will have to bring.
or
it-
the
bring it.
address of the house where the birth took place. These are the 3 things. We are only concerned on that. The place of birth is a very important aspect
Important.
because which he can do it. So that certificate has to be on the basis of that particular certificate.
Yes, that.
Secondly, the next certificate will be the institution. Some institution can give it.
Yes.
Okay, it has happened. That certificate can be given, which you will take it. And the third is the house. That third house will be an information to be given. Now, if it is immediately given within 1 year, no problem. Within 1 month, normally it is to be given. Thereupon, it can be done by the register by themselves within 1 year. And thereupon, there is a verification.
Yes, Lordship.
But if you see the verification which is to be conducted as per 13.3,
That is after 1 year. Yeah. After
After
1
1
year.
year.
huh?
After 1 year.
What is the verification? What is the kind of verification to be conducted? It is only the date of birth.
No, your lordship, any entry, because
No,
what,
no,
why?
no. Mr. Das, you are not understanding my point. Kindly see what is the verification to be conducted by the district magistrate?
So it says.
Any entry, any
No,
entry.
no,
Says
no.
that where the birth.
After verifying the correctness of the birth
After, yes.
or date on payment of so and so,
On fact
and
of birth.
having jurisdiction over the where the birth or death has taken place. So therefore, there are two things. One is the date of the where it has taken place, and the second is the correctness of the birth. These are the two things. And if in that context, if we look into the certificate, if you see, required is the place of birth.
Father's name, mother's name.
Mother's name, father's name has no business with the birth certificate.
Your-
Yes, they may put it. Mr. Das, kindly understand.
What will happen is, supposing my lord X is born today, your lordship just listen, my lord. X is born today, and the real father is not a citizen of India. Your lordship take it for example. He will put as a person who is a citizen of India. This is what is going on, my lord, in this all these foreigners case. So he will put the name of the foreigner, whether any complaint as regard the names of the father is, my lord, can it be looked into or not? Because certificate has been issued by the register, putting the name of father, putting the name of mother, putting the address.
So therefore, my question
therefore,
is,
any
this
entry-
certificate cannot be used for the purpose of ascertaining the parentage once it is contested. Now, whereas there is a finality in respect to two things. One is the place of birth,
Birth, that is.
and the second is the date of birth.
My lord, your lordship may.
Address
he
of
has
the
taken a
parents of the
point.
time of birth, that is also kept blank. You see, otherwise, these are put blank. Do you see these dates
Yes,
in the birth certificate? They are not bothered.
yes.
Father's name, mother's name may have a relevance to that effect unless it is contested. But if it is the moment it is contested, nobody, these register cannot look into that. And in fact, because that is not a certificate, you have to understand, Mr. Das, you have to also understand that this is not a certificate. Just for example, which have been held by the Supreme Court also, an Aadhaar card is not a certificate of citizenship.
It's all right, but here, my lord.
So
if you-
here, a birth certificate is only for the purpose of birth and the place of birth.
My
In
lord-
fact, it essentially certifies the fact of birth and the date of birth.
My
That
lord,
is more,
that is the
nothing
main
more than
essence.
that.
Your lordship
essence
has
of the
taken a view,
certificate.
it's all right, my lord, only my submission is, my lord, as per section 50, any entry means any entry, even the mother's name, father's name, address, everything.
An act provide for
Any entry.
regulation of births of dates and for matters connected thereto. There's nothing, they
Section
don't have no
15,
authority.
Section 15, then there is a provision under that Assam rule is there, my lord. Assam rule.
Mr. Das, Mr. Das, kindly, you see, the
Adopt-
rules
different can be
cannot enlarge the scope of the act.
That's all right, well, but any entry, my lord,
anyways,
section 15.
Anyways,
Your
go to the
lordship,
division
let
bench.
record.
I agree. This is the order which I am passing.
Regarding the other, your lordship.
I am
is
not
remarking
concerned.
that, Yes.
ये लिख ले. On the question of the once it is contested, the details so put on the question of date of on the question of the parentage of the child, permanent address of the parents, address of the parents of the time of birth of the child, same cannot be decided by the register of births and deaths. However, it is also very relevant to take note of that the birth certificate, there is a finality attached to the birth certificate. So far as the date of birth is concerned, the place of birth, as well as the place of birth. This aspect would also further be apparent from a reading of section 13.3. Section 13.3, which mandates that if we did after 1 year, the place of there is a requirement of submission of the there is a requirement of which stipulates that after 1 year, there is a requirement of a order of the district magistrate or the subdivisional magistrate or the executive magistrate authorized by the district magistrate within the area wherein the birth had taken place to verify verifying the date of birth as well as the place of birth. However, very relevant to take note of that the entire initiation of the proceedings is based upon the complaint so submitted by the respondent number 5, wherein the place of birth as well as the date of birth of the petitioners have not been contested. What is contested is the name of the father as well as the name of the mother of the petitioners which have been mentioned in the birth certificate. This court now finds it relevant to take note of Section 15 of the Act of 1969, read with Rule 11 of the Assam Registration of Births and Deaths Rules 19 so and so.
1999.
99. Empowers the register to make correction or cancellation of the entry in the birth register of births and deaths. A perusal of the said provision clearly mentioned shows Section 15 of the said Act being relevant is reproduced hereunder. From a perusal of the said provision, it is apparent that if it is proved to the satisfaction of the register that any entry of birth or death in any register kept by him under the Act of 1969 is erroneous in form or substance, or has been fraudulently or improperly made, he may, subject to such rules as may be framed by the state government with respect to the conditions on which and the circumstances in which such entries may have been corrected and cancelled, correct the error or cancel the entry by suitable entry in the margin without any alteration of the original entry, and shall sign the marginal entry and add there the date of correction or cancellation. This court also takes note of the rules. Rule 11. Of the rules of 1993. The above reading of Section 15 as well as Rule 11, the power can be exercised by the register if there is a clerical or a formal error in the register, or if any entry has been fraudulently or improperly made by making a suitable entry in the margin without alteration of the original entry. There is no power, though. Sir. Court now finds it very pertinent to take note of. This power which has been conferred upon the registrar cannot be inflated to that of a civil court to decide as to whether any fraud have been committed by the petitioners. Particularly as regards the parentage. When there is a challenge, as already observed here in above, once there is a challenge to the parentage of a person who's a person in the birth certificate, the evidentiary value of the contents of the birth certificate insofar as the name of the father and mother loses significance. This court further finds it, this court also takes note of the report which have been submitted by the learned counsel appearing on behalf of the petitioner, on behalf of the respondent number 5, which shows that the notice have been issued to the petitioners. And the petitioner number 1 had submitted a petition on 27/7/2020. Consequently, this court does not find that there is any violation to the principles of natural justice, inasmuch as the petitioners herein appeared before the inquiry held by the respondent number 4 and submitted a petition along with documents stating that the complaint so submitted by the respondent number 5 should be rejected and the matter is under adjudication in the competent court of law. Accordingly, the instant writ petition therefore stands disposed of with the following observations and directions. The very initiation of the proceedings for cancellation on a complaint being made as regards the parentage of the petitioners and the adjudication thereof on the question of the parentage is outside the jurisdiction of the respondent number 4. Accordingly, the impugn orders so passed by the respondent number 4, which have been enclosed as annexes 6, 7, and 8 to the writ petition, are interfered with. Number 3. The interference of this court to the impugn orders dated 6, 7, and 8 shall not preclude the respondent authorities to initiate a probe, proceedings on the legality of the issuance of the said birth certificates to the petitioners in the year 2015 on the basis of a registration carried out on 15/11/2013, which is almost after 2 decades from the date of birth of the petitioners. The respondent Serene, more particularly the respondent number 2 and 3 and 4, shall carry out the necessary inquiry as to whether the birth certificates which were issued to the petitioners which are annexure 1 and 2 to the writ petition are in compliance with section 13 and thereupon 13 footstep. While carrying out the inquiry, an opportunity may be granted to the petitioners to explain. The said inquiry be completed within a period of 2 months from the date of the present order. You'll get your relief by that.
But that observation, my lord, may harm in many foreigners act and all, my lord,
Why?
regarding correction of dates, correction of parentage and all. That your lordship will look into in view of section 15 says anything, my lord, even without an application, if they find that any entry is wrong, they can correct it or they can cancel it. This is what my understanding of.
No, they can correct the date of birth. They can correct the place of birth.
Entry means parentage also.
The moment you are changing the parentage later on, it will have far-reaching consequences.
But this observation is going to have a far-reaching.
This should go beyond the act, my lord.
This
This should go
observation-
beyond the provision of the
Because
act.
foreigners-
This should go beyond the provisions of the act.
No, that cannot be done.
Yes.
Foreigners
Because
Act-
otherwise, why is it having an inquiry after 1 year?
Foreigners Act and all. my lord,
Inquiry, no, it's a different thing. If it impacts the Foreigners Act, it impacts it. I can't help you. That matter needs to be challenged by somebody. They may challenge it, but the fact remains, the moment you contest the other, it loses its evidentiary value because he has no power to check that birth. How can he say that it's the mother, he's the father?
For example, my lord, if I put my name in birth certificate, my name, instead of he's the real parent. And my lord, if that is necessary for correction, how this correction will be done? That provision of law is that any entry, my lord, any entry in the birth certificate, which comes to the knowledge of the authority that this entry is wrong. His father's name is wrong, his mother's name is wrong, he can correct it. My lord. It's not necessary to go.
I'm not saying that you cannot correct it. I have not said that. What have I said? The moment the names of the birth parents which are there, the name of the address of the parents which are there, these address, whichever is there, shall remain as it is. There's no quarrel.
Yes.
The moment somebody challenges it, it loses its evidentiary value. That is what I said. I never said that it would go away.
I'm going to get relief, my lord, within a period of 2 months, hopefully I'm going to get relief.
No, in fact, no. Because of that observation, the moment you challenge that, why you have come? Because he must have filed some suit or done something to that
Property,
effect.
Malord,
Huh?
property. He is claiming that he is my brother and sisters.
He's asking for some compensation somewhere. Therefore, the moment you are challenging it, that the contents of that birth certificate loses its value as regards the father's name. Your basic grievance is that. So I therefore, I've made it very clear that if it is contested, normally your date of birth of my parents and all, it remains as it is. But if somebody contests that no, it is not so, then it cannot. And then he cannot correct that. Once it is correct, contested, the parents are contested, the place of birth is residence is contested. He cannot correct it because he does not have the ear to that effect. What he can correct is he can still correct the date of birth or whatever maybe he can do whatever maybe that he can do it. That is within his jurisdiction.
The parent's name can also be corrected if there is any application. If there is some wrong entry in the name of the parents, that also can be corrected, Lordship.
It normally it can be corrected.
But if
But the
contested-
moment you contest it, he cannot decide. There's a difference between that.
I cannot determine parentage. This is
He cannot decide the parentage.
Voter list and all voter list, everything is being contested and decided. In voter list, my name is wrongly shown, my father's name has been wrongly shown, somebody files a complaint, they ask for documents. What is your proof that your father is Mr. Das? If I cannot produce it, they cancel it. This is what is happening in voter list.
No, so they are then relying on the birth certificate.
No, birth certificate, any certificate, birth certificate, if I.
No, therefore, if that be so, now you have the Aadhaar card.
Aadhaar card is there.
Aadhaar card, can the Aadhaar card be considered to be the,
Supreme Court says,
no, can it be said to be considered to be a document of your father, your parentage? No.
Yes, parentage, they are not saying.
No,
but
you
if a
cannot.
Voter list, you can
It
incorporate.
cannot be. Can the Aadhaar card or a voter's list be considered for the purpose of parentage? No. For doing all these things, you need a civil court. But no, you have to understand. But when it is contested, otherwise it is not required. Otherwise you can sail, there is no problem. But the moment you are contesting it, that he is not my father, his parents are not there. How can an executive officer be allowed to decide that? It will have far-reaching consequences.
In this case, my lord, what has happened after the complaint filed by the respondent number 5, they found that her mother's name actually is Moni Das, Moni or something else, my lord. And date of birth is 1988 from the bank and from the school. Because they went beyond my complaint. That means because I did not complain as regard their date of birth, they went into that also. And they found, my lord, 88 is the birth of petitioner number 2. That document is there.
No, so therefore I have asked them to look into that. Because of that, they will look into it.
Otherwise, it falls only because of 13.3. It falls, my lord. Fraud, your
That I have given into them to inquire into it, to look into it. How is it possible?
fraudulently issued, your lordship has correctly recorded, my lord. It is fraudulently issued because after 1 year, you cannot issue that certificate.
It is not fraud, but you could not have done it.
Yes, could not.
No, in fact, there is a huge scam going on
Scam
these birth certificates. And they don't do it. This is not the first case of birth certificate. Many birth certificate cases, they don't do this thing, getting the magistrate's thing. Now it is, what has happened?
Now Parliament has passed a bill, my lord, which says, my lord, if it is beyond 2 years, judicial magistrate inquiry, not executive magistrate. Judicial inquiry.
But was there an ordinance before that?
No. I think the bill has been passed.
Because I
think
remember
yesterday.
doing some matter where I was taking it as a judicial magistrate. Anyway,
Now judicial.
Before the amendment in 2023, it was judicial magistrate. Before the amendment in 2023, it was a judicial magistrate.
Before 2023, there was a judicial magistrate.
Then executive magistrate comes in.
Now
Again judicial magistrate.
23.
23 from my point.
Now, this is a very old one. You are having a presidency magistrate. But then there is a judicial magistrate.
Yes. Judicial magistrate, Hassan.
Subsection 3 before amendment was
No, this was a presidency magistrate.
magistrate of the first class or a presidency magistrate. So magistrate of first class is judicial magistrate.
No. After verifying the correctness of the birth or death and on payment of fee. Now they include two things. Having over the jurisdiction where the birth or death have taken place. So this order has to be passed just for example in Koriamganj. It is only that Koriamganj thing who can do it.
Yes.
After verifying the correctness of the birth or death. Correctness of birth and death, can it be looked into a question of mother and father?
It automatically comes in. My lord. This case, Lordship.
Include whom?
What happened, Lordship, the petitioner has challenged the notice dated for 4/4/2025, Lordship, whereby all the pattadars of land under dag number 1 to 7 for patta number 512 are asked to receive the land compensation awarded in land acquisition case number 13W24, Lordship. Lordship, kindly
Are you making him a party?
I'm also pattadar in dag number 1 to 7 for Lordship, and I have been APR in the alia case in the hearing also, Lordship. And the position report was also submitted, Lordship, at page 15, Lordship, annex 2.
What is that?
But this is the share report, Lordship. I'm also in possession, Lordship.
Oh. What do you want here?
Lordship, I may be allowed to contest the case, Lordship. Petitioner while challenging
4325. Where is that document? 4325 is which is the document? You are challenging this one. 4/4/2025. Notice to the concerned pattadas to receive that pertain to acquisition of land to convert the existing area. Now, what do you say? You say that this person is not entitled to.
No, Lordship, he is also pattadar. I am also pattadar.
Then?
But he is claiming that he is the only pattadar. While filing this case, he has not made me a party, Lordship. I am also a pattadar in possession of dag number 1.
You are Nizam Ali.
No, Lordship, I am Rohim Ali.
So you want to be a party here.
Lordship.
Where is the petitioner? Petitioner is not here, na?
I have sub copy, Lordship. Petitioner name has been shown in the record list.
So he is claiming to be the sole person.
Sole person in possession is claiming this sole pattadar.
Chalo. Then how can we decide who should get the amount? Anyway, we do one thing. Today we don't pass an order here.
Okay.
Let us have it on another day on which state will dismiss his petition. You'll be happy with that?
Lordship.
Let us dismiss his petition on the next date. You be present. The counsel for the petitioner is not present when the matter is listed. Mr. So-and-so appears on behalf of the applicant. Full stop. For the ends of justice, the matter stands adjourned to be listed again on 14th of August 2026. Observe that if the petitioner is not present on the next date, this court would be constrained to pass appropriate directions. The inch of justice, this court further extends the interim order till 14/4/8/2026. Resolved.
I have instruction that they have called all the vendors.
Have you, because that was the earlier instruction on 13/7. Now, is it anything anything has happened?
The process of verification of the documents of the vendors are going on.
Eighth of the Learned Council appearing on behalf of the Karimganj Municipal Board submits. Some more time may be granted to the Karimganj Municipal Board as the verification of the documents are presently ongoing of the 80 vendors. Taking into account the above, list this matter on 16/9/2026 for an update. Right, please. What is your matter about?
No, the matter pertains to the land, this petitioner, my lords, both inside and outside the petitioner's patta land, my lord. Electrical posts and overhead wires have been installed, the APDCL and PGIC. And, my lords, I've approached them demanding, my lords, that either they acquire or compensate me. But the stand of the APDCL, my lords, in the affidavit in opposition is that yes, there are certain posts and wires. But since my land surrounds the substation on 3 sides, so they have no option but to carry.
What does the APDCL have to say?
The wires which are now in dispute is pursuant to a project being implemented by Power Grid Corporation as per a central scheme. Perhaps your lordship, consent as per the works of licenses rules ought to have been taken. Now, if the petitioner is claiming that that has not been done, perhaps the procedure under those rules have to be resorted to, my lord.
30.
My lord.
30 or 15 of those rules.
My lord. 13 and 50. 13 and 15.
I'm not aware of, and my lord, in 2015 also there are some
Give me a
guidelines.
copy of that rules. Prior to that, you have the central government 69.
My lord. Those rules are 2006 rules for the central government.
No, then I may go.
No, prior to that also there is another.
Yes, the state rules were also there. my lord. In fact, your lordship.
2015 also, there's some certain guidelines have been framed by the Ministry of Power, central government, which were subsequently adopted by the Manoj.
No, they have therefore made these rules.
Or you will have it on some other day, perhaps.
Show me that rules. There is a one provision out there. 13 and 15, where this matter needs to be looked into by that particular authority, and against that there is a reference to the district judge.
Yes.
Yeah. Determination of dispute or difference by the appropriate commission. So first it will go to the commission. Where a matter is brought to the appropriate for determination under these rules, the matter shall be determined by the appropriate within a period of 30 days and after hearing by parties concerned. Then there is another one. Oh no, 13. Where the licensee makes default in complying with any of the provisions of these rules, he makes full compensation for the loss or damage incurred by the reason thereof to the person affected as may be determined by the district magistrate or by the parties concerned. Where any difference or dispute arises, then it goes to the commission. And the commission decides within 30 days.
No, if there's any limitation aspect, no, Lordship, may kindly.
Limitation is not there because there is no question of limitation because it is a continuing.
Lordship. No, the line is active, my lords, and the line is now active, my lords, since 2022.
So it's a continuing offense. So there is no limitation to the offense. So here it is a case where the petitioner's land have been taken.
No, the land that has been taken was, my lord, there's a substation on that. And in order to connect that substation with some other transmission lines, my lord, they are separate, my lord. Lordship will kindly have page 40 for a minute. Situation will become clear. Page 40 onwards, my lord, I've given the photographs. The Lordship will see at page 40, my lords, the this substation is on the other side, my lord, the photograph below. Substation is on the other side, and this here, my lord, the number of posts, this land is my land.
Which one?
The land on which the posts on the near side are
green.
seen. Yes.
In patches.
Yes. This is all inside my land. And the land that they purchased, my lord, from me separately, on that land, this substation is there. That is not in dispute. That I have already sold. I'm not praising it.
Now what they are doing it.
Now, my lord, 9 number of posts are within my land. Lord, you will see in this the
Therefore,
other
they are using your land.
Yes, using also, and my lord's posts are also there.
So
And the
therefore,
overhead
they are
is
doing so without payment of compensation to you.
Yes.
That's the dispute.
Yes.
So that dispute needs to be resolved by the alia. Your thing is to remove it, or is it for the purpose of compensation?
The removal perhaps would not be in the public
So
interest.
it will be for the purpose of compensation. Heard Mr. A. Ganguly, the learned counsel, appearing on behalf of the petitioner. Mr. Pathak, the learned counsel, appears on behalf of the respondents.
2 and 4, my lord.
2 and 4. So-and-so, the NC Das, the learned senior counsel, assisted by Mr. A. Das, appears on behalf of the respondent number 3. Ms. A. Fukon appears for respondent number 5. The case of the petitioner herein is that the petitioner is the owner of a plot of land. He is a joint owner of a plot of land at measuring 5 bighas covered by DAG number 238 and 239 of PP number 26, situated at Botamari, Moja Mahabhairav, in the district of Punitpur, Assam.
So now I am the sole owner, my lords. Earlier I had purchased with along with another person. Now I am sole owner. Para 4 I have clarified. No.
The respondent number 4 purchased from the petitioner and his partner a plot of land at measuring 3 kathas, covered by DAG number 238 of PP number 26, situated at Botamari under Moham Bhairav Moja. By the registered sale deed dated 5/9/2013. Pursuant to the said purchase, the respondent number 4 bounded the said land with boundary walls. It may not be out of place. It is contended by the petitioner that the land sold to the epidician, to the respondent number 4, was bounded on 3 sides by the land of the petitioner. Subsequent thereto, the petitioner, by the registered sale deed, dated is the date? 26/9/2017. Purchased the share of his partner, Sri Avinash Bajaj. And the petitioner therefore became the owner of the total land of 5 bighas total land of the remaining land of 4 bighas, 2 kathas. The case of the petitioner herein is that the respondent number 4 had put RCC posts, nine numbers of RCT posts inside the petitioner's plot of land and 5 RCC posts outside his land, which has adversely affected the use of the land of the petitioner. Petitioner had submitted various communications to the respondent number 4. However, the respondent number 4 have not taken any action. It is under such circumstances the petitioner has approached this court by filing the present petition. The records reveal that this court, by an order dated 15/6/2022, issued notice the respondents number 3 as well as respondent number 5 have filed their affidavit in opposition. Respondent number 3 and who has filed?
2 and 4.
2, 3 and 5. Respondent number 2, 3 and 5 have filed their affidavit in opposition. The petitioner has also filed their rejoinder. This court have heard the learned counsels appearing on behalf of the parties. And upon hearing, it is the opinion of this court that the dispute in the instant case out the learned counsel. Upon hearing the counsels, this court had put a specific query upon Mr. A. Ganguly, the learned counsel appearing on behalf of the petitioner, as to whether the petitioner is more interested in on the compensation from the respondent authorities, or on the question as to whether the removal of the RCC pillars which are inside the petitioner's land, as well as the other pillars which are affecting the petitioner's use of the land. The learned counsel appearing on behalf of the petitioner submitted that as these pillars render as on the basis of these pillars which have been erected by the respondent number 4, transmission lines are being carried out, transmission lines have been erected thereupon. It would not be in the interest of public, it would not be in public interest to seek the recovery of possession of the said land by removing those pillars. The learned counsel further submitted that the petitioner be granted the due compensation as per law. Taking into account the above, this court finds it relevant to take note of the Assam Electricity Works of License Rules 2019, which have been notified by the notification dated P6/2019. A perusal of the said notification stipulates the manner in which the licensee is required to carry out the work. If there is it further stipulates that if there is any transgression to those rules by the licensee, full compensation for any loss or damage incurred by reason thereof would be paid to the person affected, as may be determined by the district magistrate or the parties concerned. Further to that, if there is a difference and dispute arises as to the amount of compensation determined, the matter shall be determined by the appropriate commission, by appropriate commission. Rule 13 and Rule 15 of the said rules being relevant are reproduced hereunder. This court also finds it very pertinent to take note of that a perusal of Rule 15 would show that the appropriate commission shall determine the dispute within a period of 30 days after hearing the parties. It is the opinion of this court that the rules of 2019 provide an adequate and efficacious remedy to the petitioner, whereby the compensation can be determined, and if there is a dispute, the same can be resolved within a quick span of time. Accordingly, this court, taking into account the allegations contained in the writ petition that the 9 RCC posts belonging to the licensee are still inside the petitioner's land, is within the petitioner's land, and 5 posts have and the erection of further 5 posts have affected the use of the petitioner's land, and the said actions and the transgression so alleged being continuing, is of the opinion that the petitioner as well as the respondents should endeavor to settle the disputes in terms with Rule 13 and Rule 15 as quoted herein above. Accordingly, the instant writ petition therefore stands disposed of with the following directions and observations and directions. The respondent number 2 and 4 to take effective steps for redressal of the petitioner's grievances in terms with Rule 13 within a period of 60 days from the date a certified copy is served upon the respondent number 2. In the circumstance, there is a disagreement or a dispute as regards the quantum of compensation, the petitioner is granted the liberty to approach the appropriate commission or the district magistrate has to be made there, na? To resolve the dispute amicably within the period of 60 days. In the circumstance, such resolution amicably is not possible. The district commissioner at Punitpur is directed to determine the compensation the said determination of the compensation shall be carried out within 3 months, no, 2 months, 3 months, 3 months from the completion of 60 days of the period granted to the parties to resolve their disputes. Next. If the petitioners or the respondent number 2 and 4 are agreed by the determination of the compensation by the district magistrate of Punitpur, such determinations be carried out. Either of the parties are granted the liberty to approach the appropriate commission in terms with Rule 15 of the rules of 2019. And the appropriate commission shall decide the same within the time prescribed in the said rules.
Respondent 3 also may be included, my lord, along with this respondent number 2 and 3, my lord, 4, my lord, respondent 3, my lord, Power Grid Corporation, my lord.
The respondent number 2, it shall not be a bar on the part of the respondent number 2 and 4 to rope in the respondent number 3 while carrying out the negotiation. But otherwise, you don't have a role here.
My lord, actually the project that is being implemented, the funds are going to come through them, your lordship.
As the respondent number 3 is going to provide the funds.
If
Pursuant to the last order dated 19/6/26, the IA, that is IA 2132, is tagged with the record, your lordship. It is for
Substitution.
lordship.
Who died?
Respondent number 6.
There is an application filed for substitution of the legal representatives of the respondent number 6, who expired in the month of December 2025. Taking into account that the right to sue, you are the petitioner.
Lordship.
Taking into account that the right to sue continues against the legal representatives of the respondent number 6. This court substitutes the respondent number 6 with the opposite party number 6-1, 6-2, 6-3, and 6-4. Roman 1, Roman 2, Roman 3, 1. and they are arrayed in the accompanying writ petition as respondent number 6.1, 6.2, 6.3, and 6.4. The counsel appearing on behalf of the petitioner is directed to file a fresh memo of parties before the registry of this court within 7 days, and the registry on the basis thereof shall make necessary changes in the cause title and update the same in the CIS. I stands disposed.
Your Lordship, I am appearing for respondent number 5. Earlier, the deceased respondent 6 also and 7.
So we have to issue notice upon the newly implemented.
Lordship, I have instructions to
appear.
appear. on
Mr.
behalf-
So-and-so accepts notice on behalf of the respondent numbers newly substituted respondent number 6.1, 6.2, 6.3, and 6.4. He submits that he would file, the said respondents would like to bring on record their stand. Accordingly, list this matter on 16th of September 2026. In the meantime, the affidavit be filed on behalf of the respondent number 6.1, 6.2, 6.3, and 6.4. It is also noticed that the official respondents have not brought on record their stand. The official respondents shall also is granted the liberty to bring on record the said stand.
Lordship, otherwise I have filed my affidavit, Your Lordship. Respondent number 5 and 7 have
You
also.
filed your affidavit, no?
Lordship,
I've seen.
5 and 7 I have already filed. 6, the legal heirs of respondent number 6 will be adopting that, Your Lordship. So not necessary on the next date, it may be fixed for hearing and disposed of, Your Lordship, because
Giving you the time,
Lordship,
because you have instructions to
instructions, yes. Not filed yet.
the basis of that, I can't, what that's.
Lordship.
Kindly see the order today, 8/11/2024.
What is the matter about?
Matter of the distribution of IOA house.
Huh?
8/11/2024.
PMAY house, Lordship. this one.
You have filed your affidavit, Mr. Chaudhary?
Yes, they filed.
You have filed.
Yes.
Okay. You are respondent number 9.
Yes, Lordship.
And paragraph 10, they stated that they have no role to play.
Respondent number 9 has no role.
They stated that we cannot enter their name because it is the responsibility of the central government. Now they say that we have no role, it is the role of the state government. Their only role is to distribute the money.
That's
Insertion and the deletion, that part, the skill level officers, they would be making this again.
We do one thing, we'll have it on for final disposal.
My lord,
Lordship,
they also filed an affidavit, page 116. Page 116, their affidavit, response number 6. They give a list, page 121. They said that they carried out a fresh inquiry and submitted a list. And from that list, it is found all are eligible to get, all are eligible except 2 or 3. And this honorable will make a query, they said that we cannot enter their name, it is the central government, they may enter their name. But the central government said,
We'll
but
look
only on limited purpose it can be distributed. They admitted that we are eligible.
Understood, but
Page
Mr.
116.
Mr. Ahmed,
File 1.
if you want an order
Yes, my lord.
which is of consequence, you
Okay.
need to wait for some time.
Next, any date may be fixed for NB admission, my lord.
Lordship, after delimitation, the district also sends, now it's under Nagaon district. So.
Are you? PNRD.
Lordship,
PNRD has changed.
no, Lordship.
You, all these officers are under you,
Lordship,
so
Lordship.
don't come up with this thing.
Lordship,
They are asking for what? Houses,
Lordship.
isn't it?
But
Houses. and means don't take up this technical. You see, you are giving these houses not to the rich people. Are you giving it?
Yes, these people they're giving with Excellency,
They are giving it to the rich people.
When
Ah.
we filed this petition, they deleted their name.
Ah.
Instead of.
No, no.
Verification is already
Sorry,
done.
sorry. Okay, we have it this finally. We have to take note of these people. Yeah, this we have to. What if they are entitled to? They should get it.
After verification.
Taking into account that the pleadings are complete, list this matter on 7th of September 2026 for final disposal at 2 p.m.
On admission.
There has been some subsequent factual development. Now, if your lordship kindly turns to your lordship's order, my lord, 1/4/2026. Order dated 1/4/2026, my lord. The third paragraph.
There is some amount to be paid, no?
My lord, amount has been paid, my lord. Insofar the petitioner number 1 and 2 is concerned, they have been paid, my lord. All the three cases.
Only three.
Only three, my lord. And with regard to three, my lord, your lordship had sought instructions with regard to page number 95, that house I have annexed. After that, my lord, they have filed an affidavit, which my lord will find at page 100 and relevant portion is at 104, my lord. In fact, it starts from 103 last paragraph. 103 last paragraph, my lord.
Yes.
In regards to the petition number 3, Sri Pradip Chandra Medhi, bearing registration number so and so, the same was rejected as it was not found eligible as per PMAY guidelines. As because petitioner number 3 has been living with his father who had already got benefit under so and so scheme. But at present, he has constructed a separate household and has applied for a government house under PMAYG scheme, and the same has already been surveyed under Awas Plus 2025, and if his name appears in the final list and is approved by the Gram Sabha, the concerned authority will have no objection to the same. So now they have started the, pursuant to your lordship's order, my lord, they have started the survey, my lord.
Let's get an update on that. Now, who is surveying it? Who is surveying it?
GPC, that's it.
Your department?
Not GPNL.
Ms. N. Bora, the Learned Council, Standing Council of the PNRD shall apprise this court whether the approval have been granted by the Gram Sabha in terms with the Awas Plus 2025. Insofar as the petitioner number 3 is concerned, inasmuch as the survey and the approval is to be carried out under the aegis of the PNRD. List this matter on 18th of September 2026 for an update.
Obliged. Deep below.
Lord, in this case, I have been served with an affidavit just now, man. I'll take instruction.
Entire amount has been paid, madam.
Entire amount paid?
Yes, madam.
I have to take instruction.
Lordship will have a look at.
Oh,
page-
that thing.
Yes.
That day I have
174.
asked
Just
you.
statement, now you have given the
You
clarification.
have given it, filed it now only.
Well, 174 page. And Lordship will see, my lord, main part at page 175, relevant part. Nobozoti Bora, petitioner herein, in the left hand side. Only, my lord, 2,49,000 was due. That was also paid, my lord, on August 2024. This is the latest I have today. That part has been paid.
Okay, an affidavit has been filed, additional affidavit has been filed by the WD department in pursuance to the order passed by this court on 27/7/2026. From a perusal of the said affidavit, it is apparently clear that the amount to which the petitioner is claiming have already been paid. Mr. B.T. Goswami, the learned counsel appearing on behalf of the petitioner, submits that the petitioner that he would like to obtain instructions from the petitioner on the contents of the said additional affidavit. First, list this matter again on 17th of August 2026.
Matul.
What is this, Mr.?
My lord, we are challenging a notice regarding demarcation has been, my lord, decided to be done by the JMD and the government, my lord, without any our application. They have taken up the issue by themselves.
Huh?
If my lord may be pleased to take up page 60, my lord.
Of
Page 60 of item number 20, my lord, WPC 3196.
So they are trying to do a demarcation
My lord.
without your presence.
My lord, not without our presence, my lord, without being any applications being made from our or by the neighbors, by the suo motu, my lord.
Regarding measurement of 5.2 plots of land of Patra number 80 Streetston, so and so at 11 a.m. Now you are against this.
Yes, my lord.
Now what has happened? Demarcation happened.
No, my lord. Not yet done.
Then there is no interim order also.
Yes, yes, my lord.
Then
No.
what remains in the petition?
My lord,
They must have forgotten in the meantime.
No, my lord, they
2 years have gone by.
my lord, my lord. My lord,
What do you mean?
my lord, I have tried to take the instruction today, my lord, but that petitioner I could not contact. Can it be taken up on Monday, my lord?
Okay.
Whether they
Uh,
updated status, my lord.
Mr. A.R. Bhuyan, the learned senior counsel, assisted by so-and-so, submits that he would obtain instructions as to whether any further steps have been taken in pursuance to the notice dated 31/5/2024 by the Circle Officer Gauhati Revenue Circle, which is impugned in the instant proceedings. This court have sought for this, so have also, list this matter. The state information is required, taking into account that in spite of there being no stay order for the last 2 years, if no steps have been taken, nothing remains in the writ petition. An update be placed before this court on 12th of August 2000.
My lord.
May I please, your lordship?
Yeah,
Here is the case, lordship. The phone number 7 is not eligible for holding the post of board of director as per provision of section 37C of the Assam Cooperative Act. Respondent number 7 husband is the shareholder, lordship, and the dealer of that society. So therefore, as per provision sections, indirectly as per 7 is involved in this case. And accordingly
I was in a very good mood, I suppose, on the date on which I have issued the notice. Otherwise, I would not have issued this notice. What happened? Now is the board of directors still there?
Still there.
How is it disqualified?
Disqualified.
Wife has pecuniary interest or what? Husband?
Joint family lordship indirectly receiving the benefit.
Then the act would have said so.
But and apart from that, the order passed by, we submitted representation before the assistant registrar. Assistant registrar forwarded petition before the chairman of the board lordships to take next step. Against which Respondent 7 submitted appeal petition before the general registrar.
Anyways, I don't think there's an, but when is your term ending?
It was term ending is lordship election held on
28.
27.
28. We have it in 2029 list.
Lordship.
Huh? What? Unnecessary thing. That is why I say I must have been in a very good mood for issuance of notice like this.
Case is very good.
I normally
That's
don't
fine,
issue.
lordship.
Huh?
Case is also very good, lordship.
Huh?
Case is also good, lordship.
Anyways, okay, we have it someday. Others we finish it off. list this matter on 28th of September 2026. And in disposal. That day it's finished. If it comes before me, I hope it doesn't come. It's a date fix kori dibo. Don't put the final disposal. Yes, what is this?
Your lordship, in this case, the acquisition compensation is paid, but the acquisition compensation is not paid.
Oh, yes. Has not been paid. It is further seen from the affidavit filed that the hearing will be admitted. Yes, what is it?
Lordship, on behalf of the Public Works Department, we've received our instructions. And Lordship, if Lordship permits, we'll file our affidavit in opposition.
No. It is an admitted amount. What is there? You are not paying it. You are not paying it.
Well, that amount has been released by the PWD to the Deputy Commissioner way back in 2024 itself, the entire amount.
This is a something important aspect. And does it include that amount?
That's the latest.
Therefore, there is no balance of rupees so and so.
As per the award, this is last and page, Lordship will see the communication.
Okay. You file a short affidavit so that we take it up with the district commissioner. Mr. B. Gogoi, the learned standing counsel of the PWD department have submitted an instruction dated 31/7/2026, which is kept on record and marked with the letter X. From a perusal of the said instruction, it is apparent, it is mentioned that the total amount including the interest rupees 7,68,543.10 have been released to the District Commissioner Kamrup the LA estimate. It is the opinion of this court that the said aspect be brought on record by filing an affidavit so that this court can pass appropriate directions upon the District Commissioner Kamrup. Mr. B. Gogoi submits that the affidavit would be filed within 7 days. Think that.
Yes, ma'am.
Meantime, a copy of the instructions which have been placed before this court and marked with the letter X be also provided to Mr. S.S. Roy, the learned counsel, who appears on behalf of the District Commissioner. Which one? Kamrup.
Kamrup.
So that he can also obtain instructions on the basis of the said instructions, on the basis of the said document kept on record and marked with the letter X. This matter again on 9th of September 2026. In the meantime, the affidavit on behalf of the PWD be filed on or before 14th of August on 19th of August 2026. The District Commissioner Kamrup is also directed to apprise this court on the basis of the communication which is kept on record and marked with the letter X, as well as to the affidavit which is to be filed by the PWD on the next date without fail.
Petitioner was an empaneled valuer of the respondent bank, my lord. Empaneled valuer, my lord. Valuer of the respondent bank, my lord. His contract was terminated, but subsequently by a fraud report was made to the RBI, my lord, and his bank account was frozen, my lord. Last occasion, your lordship, kindly see the
What
order.
are these additional affidavits filed?
Your lordship, this is filed by the respondent number 427. This is with regard to the RBI circular on the last occasion that was discussed, that why the fraud reporting was done. This is the circular. Your lordship may kindly turn to page number 140.
It's okay. We do one thing, we file. You want to take any opportunity to rebut to this additional affidavit? No.
Copy. My lord, additional affidavit, I was not given, served the copy, my lord.
What?
No, copy those has been served.
No, my lord, I have, no copy was served to me, my lord.
Yaqub Ali Sheikh or whatever fellow. For AHMR
That,
Chaudhary.
if, then, my lord, I was not aware, my lord, of that affidavit, my lord.
The respondent number 427 have filed an affidavit, additional affidavit. Counsel appearing on behalf of the petitioner submits that he would obtain necessary instructions on the same. This matter again on 19th of August 2026.
Okay.
My lord, this matter, my lord, the petitioner is claiming a compensation for the death of her son due to electrocution. The son of the petitioner died, my lord, due to electrocution, my lord, in 2022.
Who died?
The son of the petitioner. He was engaged in a, my lord, the borewell work in the house of one Kamakya Singh, that is, my lord, private respondent here, my lord. And my lord,
Were engaged as?
My lord, labor, my lord.
By?
By one Kamakya Singh, that is respondent number, my lord, 4, my lord.
Who is Hemangodi? Kamakya Singh.
Kamakya Singh.
Who is Kamakya Singh?
He is the owner of the land. Under the land, my lord, there was a live electrical wall.
And what is the electrical accident report?
My lord, it's a fault on the part of the previous owner, my lord, who sold the property to the Kamakya Singh, my lord.
There is a, my lord,
We have
report
filed
the-
an affidavit today, my lord, that is not on record.
My lord, the
Mr. Bidas,
My lord.
Standing Counsel of the APDCL submits that the affidavit has been filed on behalf of the APDCL. Taking into account the above, list this matter again on 21st of August 2026. In the meantime, the affidavit of the respondent APDCL be brought on record by the registry. Petitioner in the meantime would be at liberty to file any reply thereagainst.
matter may be fixed on 22nd, man. 22nd.
Second is Saturday.
20th, man.
23rd is Sunday.
No, man, 20th, man. 20. 20, man.
Not 20.
On the next
20,
matter, my
no.
lord.
Why
Monday.
20? This is not a matter of 24th. Yes, what is this?
Regarding ZIRAP compensation. ZIRAP compensation was given to the writ petitioner, my lord.
Thereafter,
Thereafter, somebody complained to the additional deputy commissioner that I am entitled to ZIRAP.
you have
That is
done
the
that.
dispute.
I gave you the liberty.
Yes, lordship has given liberty, my lord. But
8/4/26.
my lord, what happened, my lord? The petitioner has already filed an money suit, my lord, in the year of 2025, my lord. Said money suit is withdrawn today, my lord. Someday, my given, my lord, we will file.
Okay. Mr. So-and-so, the learning counsel who appears on behalf of the respondent number 6 submits that under the misconceived notion the petitioner had filed, the respondent number 6 had filed a money suit.
Yes, my lord. 1/2020.
You filed, na?
Yes, my lord. I
Filed a money suit. And the said money suit has thereupon been withdrawn, and the respondent number 6 is taking effective steps for filing an appropriate application under section 3H4 of the National Highways Act 1956. Taking into account the above, list this matter on 2nd of September 2026 for an update.
Obliged, my lord.
This,
My lord, in this matter, my lord, earlier Ms. D. Sonwal, she was appearing, my lord. Now she has requested me to appear. We will file wakalatnama shortly.
they filed.
Not file, my lord. We'll file instruction by
Okay.
telephone.
Mr. S. Dotto, the learned counsel submits that he has been recently engaged in the present proceedings, and as such, some time may be granted to him to account the above. List this matter again on 7th of September 2026.
29 to
29.
May I please, Lordship?
What is this?
This petition filed, my lord, against the police atrocity, my lord.
Huh?
Yes, my lord.
Police atrocities?
My lord, the petitioner, my lord, were accused in a particular case, that is Themaji, Dhekazli PS case number 135, 2004, my lord. And after obtaining bail, my lord, petitioners were approached before the respondent number 5.
Inquiry done?
My lord, inquiry done. My lord, respondent number 3 file affidavit, my lord. Respondent file 3 file affidavit, my lord. In the affidavit, my lord, they admitted that yes, there is, my lord, respondent number 5 and 6, my lord, involved with the.
No. 5 and 6?
My lord, respondent number 5 is the IO of the case, my lord, and 6 is the informant, my lord. And both, my lord, respondent number 5 and 6, my lord, physically tortured the petitioner number 2 and 3.
Absolutely false, sir. And I never, my lord, admitted, my lord, I have.
Okay. Inquiry, what does the inquiry say?
Can you see the page 98 clear everything, my lord.
Case of constitutional tort.
Yes, sir.
Now, Lordship, they are claiming, Lordship.
The case of constitutional tort. They are asking for some money, isn't it? They are asking for compensation.
My lord, compensation as well as, my lord, the IO, my lord, since the IO is, my lord, punished, my lord, in illegally, my lord. So, my lord,
Have you approached? You have a police commission, na?
my lord,
Accountability. Police Accountability Commission.
Police accountability. Have you approached them?
my lord, I approached before the, my lord, superintendent of police, my lord, thereafter, my lord, DGP, my lord.
No. Have you approached
No,
the
no,
police
no, my lord.
accountability
No,
commission?
no, my lord.
They are the right person. They are the person who will give all this recommendation where to put this respondent. Mr. Botakur already there. Anyways, we take it up on summary. Pleadings are complete.
Yes, my lord.
This matter for taking into account the issue in hand, this court fixes this matter on 10th of September. 10th, I have a 15th of September 2006.
No, after
Putting
15
it on a Tuesday.
No, after 15 minutes.
Absolutely no. Who are you? Why 15?
But I will be available, madam.
You are not available from tomorrow.
No, on 14 and 15 of September, madam.
Okay.
I'll fix it on 15 minutes.
Okay.
That's right.
On 17th of September.
Yes.
Oh, let's do.
May I please, Your Lordship? Your Lordship, this matter pertains to non-issuance of a notification under subsection 4 of section 21 of the right to fair compensation and transparency, Your Lordship, in land acquisition and rehabilitation and resettlement act, Your Lordship. On the last occasion, the state respondent sought time, Your Lordship, as
Issue a
regards
yeah, under
subsection 4 of section 20.
section 21.
Yes, Your Lordship.
What is section 21?
Yes, Your Lordship.
What is section 21?
Yes, Your Lordship. I'll satisfy Your Lordship. Your Lordship, at the present moment, Your Lordship, the engaged counsel, Your Lordship, due to some personal difficulties, I do not have the brief with me, Your Lordship.
Counsel engaged is not present, for which the matter stands.
My name is there in the Wakalatnama, Your Lordship, but however, I do not, my name is there in the Wakalatnama.
Then what are you saying?
Your Lordship, I do not have the brief.
Counsel who has appeared is not has submitted that he has inconvenienced today, for which the matter stands adjourned to be listed after 6 months,
Your Lordship, 4 weeks, Your Lordship.
have listed on 25th of September.
Yes. Much obliged, Your Lordship.
My lord. Respondent number
Yes,
five and
affidavit
six.
filed by respondent number 5 and 6.
My lord.
What
Five
is
and
the
six.
send of the affidavit 5 and 6? What are you? Who are you?
The land that we have purchased doesn't belong to this portion of the land, my lord. We have given the sale deed also.
This is the case of settlement operation.
Settlement operation. my
He is
lord.
asking for settlement only.
Yes, my lord.
Yes.
He is asking for settlement. We
He has not mentioned which dark number, patta number, nothing.
nothing.
Was
Only
retrenched from Darbit Estate in 52, and since then they have been residing. And therefore could not refund the money, so they have been allowed to reside there. And they have not been issued pattas. Why are you here?
but they have made us a party, my lord.
Why?
Because we purchased a plot of land, my lord, which is nearby to this, my lord, tea state land.
So you have not
Which is-
purchased the tea land.
No, my lord.
So
Our
you
land
know-
is different from that
No,
land.
so therefore,
State has to
these
file.
the retrench, but first of all, whether there is any fixation of land sealing act.
No, my lord. It is a restricted tea estate land, my lord.
Tea state land, you don't get a settlement because the tea state already patta has been given to
My lord.
somebody.
My lord.
The land has to become a government land.
My lord.
Has it become government land or not?
My lord.
How?
This has been but the tea
Wait,
estate.
wait, wait.
tea estate-
Yes, government, what is your stand? You bring your records then.
We have not received any instruction, but as it appears, my lord, land belongs to the tea estate.
Therefore,
will
if
they
it
will-
belongs to the state, it is the, you cannot do
We
anything.
cannot do it. But I'm awaiting instructions. Awaiting instruction, I have not received.
Which you have to get your instruction from whom?
From the
Kachar.
Kachar.
Get your instruction from there. Mr. P.K. Mehdi, the counsel assisting the Mr. B.J. Talukdar, the learned senior counsel, shall obtain instruction as to why the petitioner, as to whether the petitioner is entitled to the claim made in the petition. This matter again on 18th of September 2026.
May I plead, Lordship? Lordship, complying last order, we have filed our affidavit for respondent number 456.
What happened? Affidavit has been filed on behalf of the respondent numbers 4, 5, and 6 in terms with the order dated 27/7/2026. What is your stand?
Lordship. Lordship, we are ready to issue the work order to the petitioner.
Oh,
Yes, yes, Lordship.
Now I remember.
Yes.
The case is there is on account of some complaint.
Yes, Lordship.
Yes, sir. You did not. Now
Yes.
you want to.
Yes, yes, Lordship.
So therefore,
Because he
on the
withdraw
basis
his
of that, I
complaint,
will
yes.
take- The heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, Mr. So-and-so appears for a response.
456.
The petitioner has approached this court being aggrieved by the inaction on the part of the respondent number 4, 5, and 6 in not issuing the work order to the petitioner. Full stop. The respondents have not issued, the respondent number 4, 5, and 6 earlier have not issued the work order on the ground that there was a complaint filed against the petitioners.
Not against the Lordship petitioner, because the work to be executed, it was complained that it was going across some patta land.
There were certain complaints However, subsequently, when the said complaint was withdrawn, respondent number 4, 5, and 6 intends to issue the work order to the petitioner. Paragraph number 6 of the affidavit filed by the respondent number by the executive officer of the Bilasipara Municipal Board, page 39 of the being relevant, is reproduced hereunder. To do the same work at the same rate, Mr. Counsel, the learned counsel appearing on behalf of the petitioner submits upon instructions that the petitioner is willing to carry out the said work. The rate fixed earlier. So taking into account the contents of paragraph number 6 of the affidavit filed by the respondent number 4, 5, and 6, and deeming it to be an undertaking given before this court, that the respondent, then we can have quoted. So we allow you to withdraw then. Withdraw then, he's going to give it to you. That I've already recorded that, no? The learned counsel submits that for the petitioner submits that as the respondents numbers 1, 4, 5, and 6 is willing to issue the work order to the petitioner, and the petitioner is ready to carry out the work as per the earlier rate fixed. The petitioner, therefore, has no grievances and accordingly submits that the petitioner would not like to pursue the present proceedings. So taking into account the contents of paragraph number 6 of the affidavit, the respondent number 4, 5, and 6 as an undertaking. Now, taking into account the said submission, the writ petition stands closed. Full stop. This court observes that the contents of the paragraph number 6 of the affidavit filed by the respondent number 4, 5, and 6 shall be deemed to be an undertaking given before this court.
Oblige.
This matter may be taken up some other day.
You have not filed reply?
We have filed it.
You have filed?
Reply.
It has not come on record.
Reply, we have filed it. Yeah, actually we have filed already.
Mr.
J.
J. Kolita, the counsel appearing on behalf of the petitioner submits that an affidavit in opposition, a reply has been filed to the affidavit in opposition filed by respondent number 4 and 5. However, the same is not on record. List this matter on 16th of September 2026. In the meantime, the affidavit of the respondent of the petitioner be brought on record.
Oblige.
My lords, this matter we have affidavit we have sent for vetting, my lords. Affidavit has been sent for my vetting.
I was therefore with a smile. Since you have filed. Then I thought, oh, it has gone for vetting.
Instructions are received, my lord, then we write it. We'll file it within 1 week, my lords. We'll file it within 1 week.
Mr. Neil Gogoi, the learned standing counsel of the Forest Department, submits that the affidavit would be filed within a week's time. So it is seen that on the earlier occasion also, time was granted to the Forest Department. Accordingly, list this matter on 26/8/2026. A final opportunity is granted to the Forest Department to bring on record their stand by filing the affidavit on or before 24/8/2026. It is observed that if no affidavit is filed, the Forest Department shall be precluded from filing any further counter to the in the present proceedings.
Very please, your lordship. Relating to my lord, my younger brother, who took a loan of rupees 2,80,000 from Assam Financial Corporation, my lord, in the year 1994, my lord. For business establishment, my lord. But since his business was not going on in flourishing way, my lord, he had to, my lord, shut down his business. And subsequently expired in 2018, my lord. But during his lifetime, he could not pay single EMI in lieu of the loan availed from the Assam Financial Corporation, my lord. Then, my lord, the petitioner being younger, eldest brother, my lord, Assam Financial Corporation.
Some affidavit has been filed by respondent number 2 and 3.
Man, we have filed reply, but we have made one mistake, an inadvertent mistake in in my reply that the one, my lord, legal hair, and my sister. Actually, he was not expired, but we made a statement, my lord, he expired, my lord. It does not cause any, my lord, any damage, my lord, because, my lord, the plot of land wherein, my lord, already, my lord, residential flat has already constructed, everybody has taken his share. So when to rectify, my lord, when to file an application, my lord, to rectify that mistake, my lord, I will be allowed, my lord. Because it is fact that, my lord, against 2,40,000, I have already paid 31.
You want the original documents?
Yes, original document, that. Yes,
That's your simple prayer.
yes.
Has the loan been paid?
Yes, my lord, against 2,40,000, 31 lakhs, 550.
Mr. Counsel, wait.
Yes, my lord.
Now, why are you not returning?
Yes, my lord. Loan was settled, my lord. My settlement amount was paid, but there was a condition that a case was pending filed by the petitioner against the corporation. There is a against the corporation, my lord. Corporation instructed that case must be withdrawn and the settlement amount must be paid within stipulated time. The petitioner paid the amount, but case was not withdrawn, my lord.
What case is that?
One writ petition was pending, my lord.
Where is the writ petition?
Yes.
Is it pending?
No, my lord.
So then there is no inhibition.
Therefore, corporation issued number of letters to the petitioner, my
That's different.
Yes, my
Now
lord.
you got the money.
Yes,
Why
my
you are not returning it?
No, my lord. As case was not withdrawn, my lord.
Now the case is not there.
The account was not closed, my lord. Case was not withdrawn, my lord. Account was not closed, my lord. Therefore.
In their affidavit, they say.
Yes, my lord.
Para 5, WBC
Yes, my
3347,
lord.
filed against the.
Account was not closed, my lord. As the account was not closed, my lord, therefore petitioner issued one urgent letter, my lord. Your lordship may kindly see.
Madam, whatever may be,
Yes,
fact
my lord.
remains that they have an account or they should have withdrawn. Now, as regards the money, you have received it.
Yes, my lord.
Once you have received the money, there is no question thereafter. Now, the question was for withdrawal of the writ petition. The writ petition is no longer in existence.
No longer here, but it is withdrawn. It is made, my lord.
It was withdrawn after.
Whatever may be, as of now, why the state is not returning the amount and the amount, what do you call the deeds?
My lord,
Chalo.
the
We
mortgage.
pass that a final order on next date. This is the matter on 7th of September 2026 for final disposal at 2 p.m. Madam, this is
My lord,
not a thing which we'll expect.
Mortgage property is a joint family property, my lord.
Maybe
Yes, my lord.
whether he is entitled or not, but this is not a ground you can take, madam, that case or not withdrawn when the case as on date no longer revives.
Only
It's a different thing that there are other persons who are there who had deposited and all. You ask them to put a condition that anybody who takes it will put it with an indemnity that he is going to give it and indemnify the corporation if anybody claims those documents. Put those conditions out there. But you cannot retain these documents.
It is a joint
Once
family.
the amount has been cleared.
My lord, therefore petitioner corporation only instructed to furnish a legal year certificate and a no objection certificate signed by all the legal heirs that they have no objection.
Have you put on that affidavit?
Yes.
Have you put that thing in the affidavit?
Affidavit, my lord, they have filed a reply. In the reply, my lord, the petitioner has stated a false statement before this honorable court. The petitioner has stated, my lord, I am reading, my lord. that Bonasri Sharma was also expired. His younger daughter, sister, my lord, Bonasri Sharma was also expired. But before her death, she issued no objection certificate. My lord, Bonasri Sharma is alive, my lord. The petitioner has false statement before this honorable court by filing, by showing affidavit, my lord.
All these things are there. There's no quarrel with that. But the
He is
fact
la-
remains, you see, what he has done is to the court.
Yes, my lord.
That this court will deal with it. But the fact remains that you are to provide the year subject to these documents being submitted. So let the petitioner submit those documents. You being satisfied, you will allow. That's it. You see, madam, the question is the resolution of a dispute, either by passing the specific orders or by somewhere by way of an amicable. Here is a case where the amount has already been paid. There's no quarrel, the amount remains. Amount has been paid.
Amount has been paid.
Now,
but
the second aspect is withdrawal of the case. The case has been withdrawn. As of now, it doesn't remains. Now, therefore, now the question is, you ask that you kindly submit these particular documents, you are going releasing it, isn't it?
Yes.
Now, against that, what he has done, that he said that once one of his sisters died, but the sister did not die. Now, if when you are asking him to submit those documents, listen, if he submits those documents, if you are satisfied, release it.
Yes, we have petition, corporation has not satisfied, my lord. And
If
there
he's not
is-
satisfied, we'll look into it. But first of all, you have to give him a chance of being satisfied, na? Let him submit those documents to you. Has he submitted a death
he has
certificate
not
or bonus?
submitted. Yes, but if he submits the
that is
legal
what my
cert,
question.
always we are requesting him, my
So
lord.
therefore,
yes,
on
my
the
lord.
next date, on the next date, we pass that order. If he has given a false statement, we'll take it up. That's another aspect of the matter.
my
But that doesn't give you a right to retain those goods. That's it.
Yes, my lord.
We'll have it on 6th.
And legal expenses must be paid, my lord, by the petitioner to the corporation. There is due, my lord, about 52,000 legal expenses for 2 years, my lord, as the case was pending, my lord. Case was not withdrawn. If he pays the legal expenses and the documents, then corporation will hand over all the legal documents to the petitioner. my lord.
Against
Corporation is ready. my
against
lord.
2,40,000, we have taken 31 lakhs, 565,505. Against 2,40,000.
If the
Yes, what is this?
Also, in this case, the petitioner is the owner and possessor of a 3 kata land since 1975, Your Lordship. And she has been pursuing with the circle office for mutation of her name in the said land, but it has not been done till date.
Okay, the
Suddenly-
respondents herein directed to place their are directed to place their stand before this court as to whether the petitioner is entitled to the reliefs as has been sought for, taking into account that the notice was issued as far back as on 17/9/2025. The affidavit be filed on behalf of the concerned respondents on or before 16th of September 2026. The list of matter again on 23rd of September 2026. Mr. J. Hendrick appears on behalf of the district administration.
Highly obliged.
Yes, what is this?
Milord, matter relates to Milord land and Jirat compensation, Milord. We have challenged an order of the Milord Deputy Commissioner, which is at page Milord 56. 50% has already been released and 50% had been directed to be deposited before the learned Milord District and Session Judge Kachar Silchar. Milord, this order we have challenged. Now, during the course of the proceeding, Milord, it has come to light. Their stand is that our land had not been acquired, Milord. But in the physical possession, Milord, the land had already been acquired, though in the notification as well as in the papers, we have also found, Milord, that it had not been acquired. Now, physical possession is there now, Milord. If my learned friend on behalf of the NHI, Milord, brings the instruction, then, Milord, this petition may not be required anymore, Milord. If
Who
it had,
appeared for NHI this year?
Milord, the National Highway and
Have it on another date, on a quick span of time. And what is this IA for?
IA is stay vacating, your lordship.
There is a stay of
Because of the stay operating, your lordship,
My lord.
we have not been paid the 50% remaining amount, your lordship.
Is this
And on the last three occasions,
application or in the stay vacating column on 19th of August 2026. The interim order passed earlier shall stand extended till the next.
My lord. Obliged.
Matters here related to the allotment of the showrooms.
Reply file.
Actually, your lordship, what happened from the affidavit of the respondent video filed by the video, your lordship, that it reveals that the whole process has been conducted as per the violation of the rules, your lordship. That's why violation of financial rules, Assam Financial Law 2002. That's why, your lordship, we have filed another writ petition, your lordship. That have not been listed till it was filed on 31/7/2026.
What is the number?
9332. Serial number 9332. Not yet number, your lordship. I got the serial number, your lordship.
Okay, you want time for that?
Time for.
It will become infractions, my lord, then. It will
No,
become automatically infractions, my lord. Please, because they have already filed another writ petition.
No, your lord. Here,
In fact, one of these writ petitions were filed initially, they came before this honorable court. Their claim was in 2011, they were given, my lord, some allotments of these shops. They wanted to continue with that. There was a tender process in between. We were we were the successful tenderers, bidders. Then the matter went to the Supreme Court. All the courts they lost. Now they're again they filed another second case saying that they've been given possession by and our agreements have been cancelled. That the department has said that these are not there in the records. So on the basis of false agreements, they have again tried to file a second case. And now they're claiming, in fact, we are the successful tenderers. We have been given possession and we are in possession of those shops.
When did you file the writ petition?
we filed on 31/7/2026.
We do one thing. It be there. I think we need to finish it off.
Well, understand.
So let's have it on, finish it off on 20 August.
20th August. Right.
This does matters on 28th of August 2026 at the top of the list for final disposal. 20.
Make this, your lordship.
Where is this?
Well, in this matter, there was a demand by the authorities of pending establishment charges. Now, when we came before this honorable court, that the renewal was due, and our application for that was consideration was made long back.
Name not shown, so we missed it. Name is not reflected, my lords. Only in the corridor in the afternoon he said. Otherwise, his license has been renewed.
License renewed, madam. Only thing is that they would take a call because 24 we had submitted an application that so far as the establishment charge pending is concerned, what do you do with that?
D. Gogoi, the learned counsel of the Forest
Excise
Department submits that on account of the name of the Forest Excise Department, Standing Council of the Excise Department not being shown in the cause list. The petitioner could not, he could not prepare for the present proceedings. So taking into account the above, is this matter again on when? Urgency, no urgency.
I mean, it can be disposed of also any day, lordship.
Senior, my lords,
Everything I've done.
any date the senior suggests, my lords. Any date my
Renewal
senior
is
suggests.
what only party
You
they
don't want to file affidavit.
could, brother.
We have to take instruction, my lord, because otherwise he's too.
Therefore, it is you. I'm only asking you.
Let it come after 2 weeks, my lords.
2 weeks, anything.
Okay, 2 weeks.
Is this matter on 25th of September 2026? In the meantime, the respondents shall bring on record their stand by filing their affidavits.
Right.
Item 41 and 42, my lord, instructions awaited, my lord, doing this some time, 3 weeks time. Instructions having been awaited, Mr. S. Dr. the learned counsel appearing on behalf of the respondent PNRD seeks for weeks' time to bring on record its stand. This matter on 18th of September, non-payment.
Yes, ma'am.
This matter on 7th of October 2026. In the meantime, the
we'll file.
stand of the PNRD department be brought on record.
We'll file. Yes.
42 same.
Same, 41, 42.
Aru, Peter.
Yes, my lord. This is that termination matter, my lord, IOCL, my agreement was terminated, my lord, dealership agreement. So they sought time last time, my lord, for filing counter. That has
Yes, your lordship, I am appearing on behalf of my senior and Borough for respondent IOCL. Your lordship, my senior had to leave for medical emergency, and he has asked me to pray before the honorable court for some time for filing the affidavit in
Okay,
opposition.
file the-
Your lordship, can it be after 14th August? He will be out of station.
Council appearing on behalf of the IOCL seeks for an accommodation. Post- Taking into account that no affidavit has been filed. Spite of notice having been issued on 7/4/2026. And further, time has been sought for. List this matter again on 9th of October 2026. The interim order so passed earlier shall continue till the disposal of the petition.
Obliged.
Item 44 is non-consideration of my restructuring plan, financial restructuring. And item 45 is connected. Item 45 is basically seeking remittance of
Your
BG
lordship, in this case, the JLM has not come to the decision because after giving the proposal of the restructure, in the JLM, it has been sent for forensic audit. So it will take time.
Some time is required.
Yes, your lordship.
Time is required.
Yes,
Yes.
your lordship.
How much?
Your lordship, 4 week may be given.
Mr. Who you are paying for?
2, 3. 2, 4, and 5.
Respondents in the present proceedings are seeking for an accommodation on account of the GRM, na?
GLM, JLM, Joint
JLM is
Lenders
what?
Forum,
Joint lenders meeting.
Joint Lenders Forum meeting.
Joint ledger
Lenders.
Lenders
Joint
meeting.
Lenders meeting.
meet have not yet been held.
No, it has been held, but decision has not been.
Oh, the have sought for time on account of the fact that the joint lenders meet having been held, the decision is yet to be taken.
Yes, sir.
So taking into account the above, list this matter on 9th of September 2026 for an update.
There is an interim, in item 44, there is an interim that may be continued.
Not interim is there.
No coercive
No
steps.
coercive action, your lordship.
8/6 to
Earlier, on
Yes.
8/6/2026.
On 8/6.
Then shall stand extended till the next.
Next matter, my lord, item 45 is connected. That is for recovery of the money that was recovered through invocation of bank guarantee. In that, a reply is awaited.
Is the matter along with.
I am grateful, ma'am.
46 instruction received. I need some time to file it.
Instructions sought having not been placed. What is this? What is this issue?
Land acquisition, compensation.
Instructions. Mr. J. Hendricks, the learned counsel appearing on behalf of the district administration seeks for 4 weeks' time for filing the affidavit. This matter again on 23rd of September 2026. In the meantime, the affidavit be filed on behalf of the district administration as to why the compensation have not been paid to the petitioner. Has the land been acquired?
Yes, your lordship.
May I please, your lordship?
Please,
In the last occasion, your lordship, I have filed a representation on 25/7/25. Now they have sent a letter that they have no, no documents about receipt of the said representation, whereby I have paid for remission or to accept my surrender, your lordship. So I may be allowed to submit again that representation, your lordship, 25/7/25.
Is the matter on when Friday?
History, my lords, I have filed the affidavit on third. And it
Already they have filed the affidavit, my lord. At last, my lord, I need some time to file a reply, my lord. They have.
denying my
There was a counsel appearing on behalf of the petitioner seeks sometime to obtain instruction and file the reply to the affidavit in opposition filed by the respondent number 7.
7.
Is this matter again on 2nd of September 2026. In the meantime, the reply be filed.
In this case, I have received instruction, my lord. Sometime may be granted to file affidavit.
Mr. S. Dr. the counsel appearing on behalf of the PNRD submits that he has received the instructions and would be filing the affidavit in 2 weeks' time. Is this matter on 28th of August 2026? Meantime, the affidavit.
Highly obliged. May it please your lordship.
Your lordship, this matter relates to non-payment of contractual dues.
My lord, we have
Non-payment of
disputed it, my
contractual dues. Your lordship, there is a dispute, but can I just for a moment take your lordship to paragraph 5 of their affidavit?
Wait. There is a dispute.
Dispute, my lord. In fact, we have stated that, my lord, the completion certificate itself is fake. The serious allegation is there.
Yeah,
The person will post it on the day, my lord, to.
This the matter on 11th of August for final disposal.
Lordship.
highly.